Bom dia a todos. Vamos dar início, então, ao Second Digital Market Symposium. É um evento que já foi promovido no ano passado, agora ele é promovido numa parceria entre a Associação Lawgortihm de Pesquisa em Inteligência Artificial e o Legal Grounds Institute, como vem acontecendo em todos os campos, né? A inteligência artificial cada vez mais ubíqua vem tomando espaço em todo e qualquer assunto, né? Na discussão sobre concorrência e a dinâmica dos mercados digitais não é diferente. A inteligência artificial vem tomando um papel cada vez mais importante, principalmente depois dos grandes modelos de linguagem e das IA generativas, na própria dinâmica dos mercados digitais. E por essa razão, então, a expertise dos pesquisadores da Lawgortihm é importante para fomentar esse debate, essa parceria entre esses dois institutos, que já são parceiros, têm diretores em comum, vem bem a calhar agora na promoção desse evento, que nós pretendemos que ocorra todos os anos daqui para frente, né? Até porque a dinâmica dos mercados digitais e agora com os mercados de IA é extremamente veloz e traz desafios provavelmente todo ano, né? Os temas mudam, pontos que são antecipados muitas vezes se tornam mais graves. Existem saltos tecnológicos que exigem rediscussão dos problemas. Então nós vamos ter aí pela frente muito caldo e muito tema para debater. Eu quero dar boas-vindas a todos. Nós estamos com a agenda cheia, começamos um pouquinho atrasados. Então eu vou aqui já encerrar minhas palavras de abertura e passar aqui primeiro também agradecer ao Berardo e a Melina e o Francisco pela organização, né? Pelo apoio na organização, e passar a palavra para a professora Elisa Bechara para dar as boas-vindas aqui em nome da Faculdade de Direito.
Bom dia a todas as pessoas que estão aqui conosco, desculpa, presencialmente, e quem nos acompanha, quem nos acompanha online nesse evento híbrido. Eu queria manifestar minha alegria imensa de estar aqui hoje. Primeiro ladeando meu amigo, meu colega de turma, o professor Juliano, no Maranhão, mas alegria fundamentalmente por estar aqui dando as boas-vindas para esse evento, esse segundo simpósio de mercados digitais, organizado por esses dois grupos que já são potentes e tradicionais aqui, revolucionários da faculdade, né, o Lawgortihm e o Legal Grounds. Como é importante, né, a gente pensar nessas questões, como é importante o papel da faculdade, né, na linha de frente dessa discussão. Vejam que esse não é, né, um tema tão novo assim, né? Já há 5 anos a gente tratava do chamado direito 4.0, né, que voltado a dar soluções a essas questões provocadas aí pelo avanço tecnológico da chamada quarta revolução industrial, não é? Já desde aquela época, né, a gente falava que não se tratava mais de ter uma visão do futuro, mas de algo que já estava acontecendo, né? E de lá para cá a gente vem sendo atropelado, né, pela realidade, pelas novas tecnologias, pela revolução que isso causa, em especial na esfera da economia, né? A gente está falando de uma nova economia, dessa economia digital, a gente está falando das plataformas digitais, principalmente aquelas em hiperescala, né, que modificaram profundamente as atividades de comércio, as relações empresariais e as próprias relações sociais. E o direito precisa responder a esses desafios. E isso não é fácil, isso não é trivial ao direito, né? Em razão das nossas tradições ou das nossas tradicionais dificuldades de adaptação né, de compreensão dos novos fenômenos e de respostas minimamente estruturadas no sentido mais sistêmico, né? O nosso mundo jurídico ainda é um mundo do tradicionalismo, de permanência, né? E a gente precisa de mudanças estruturais, eu diria, no próprio direito, né, para atender a essas questões. Quando a gente fala dessas inovações tecnológicas, o professor Juliano mencionou, né, a inteligência artificial generativa, né, a gente está diante de um debate profundo, um debate interessantíssimo sobre as próprias fronteiras entre tecnologia e a condição humana, né? Quer dizer, o quanto a gente pode caracterizar uma ação como humana, o quanto a ação humana pode ser reproduzida ou substituída, né, pela inteligência artificial, mas acho que a questão central, na verdade, é como utilizar essas novas tecnologias em benefício do desenvolvimento social, em benefício da dignidade humana, portanto, de uma forma minimamente positiva e, eu diria, necessariamente regulada, né? Claro que a gente tem esses avanços tecnológicos que elevaram a sociedade a um patamar de desenvolvimento sem o qual hoje a gente não consegue imaginar como é conviver. Então, a gente é muito, muito dependente da tecnologia, e isso é uma realidade sem volta, e é uma realidade sem volta também para o direito, né? Então, não adianta a gente simplesmente criticar essas novas tecnologias, porque a gente está usando elas, né, o tempo todo, né? Quando a gente fala das plataformas, por exemplo, quer dizer, da hora que a gente acordou até agora, quantas foram as que a gente já usou, né, só hoje, né? E usou gratuitamente, né? O que chama atenção, né? Porque quando o produto é gratuito, ou o serviço vendido, na verdade, não é vendido, é gratuito, o sinal é que o produto é a gente, né? Então, enfim, a gente tem que pensar criticamente dentro do que a gente chama dessa sociedade da informação, que rompe, né, o modelo tradicional, trabalho, capital, rompe o capitalismo industrial e rompe no âmbito de um neoliberalismo em que a gente se vê muito instrumentalizado também, né, em relação a essas tecnologias. Eu estou falando aqui da capacidade das plataformas de armazenar dados, de leitura, de compreensão desses dados, né, da capacidade das plataformas de construção e manipulação do nosso comportamento, inclusive do nosso comportamento no sentido de consumo, né, nosso comportamento econômico. E tudo isso tem consequências inclusive geopolíticas, né? Então, a gente tem um campo, e aqui eu não quero entrar em nenhum dos temas específicos, nós temos 2 dias de debate aí tratando de temas muito, muito, muito importantes, né, e muito variados dentro dessa temática ampla, né, mas o fato é que a gente vai ter que pensar sobre isso, e pensar sobre isso sob a perspectiva dos seres humanos, né, de novo, né, pensando no desenvolvimento social, né, diante de um poder econômico, né, que é bastante claro, que é crescente e que está subordinando aí outros interesses ou interesses sociais, né, e um poder econômico que não tende à autorregulação, né, não traz benefício nenhum à autorregulação, salvo em casos muito específicos, onde eu vejo riscos econômicos para o desenvolvimento das atividades. Senão, né, a ideia de regulação tem que ser uma ideia que vem de fora e tem que ser muito bem pensada. É importante ver, quando a gente fala de regulação, que a gente não está falando de um mero esforço, né, no sentido de reforçar os nossos velhos instrumentos do direito, como eu falei no início, né? É preciso pensar em novos instrumentos, né? Pensar de uma forma diferente. E é isso que tem feito esses 2 grupos, né? É isso que tem feito o professor Juliano Maranhão, né? E é isso que deve fazer a academia, né? Quando a gente fala no ensino do direito, né, em pleno, né, período em que a gente tem quase 2.000 faculdades de direito, ou cursos de direito no nosso país, né? Quando a gente pensa na qualidade do ensino jurídico e no futuro do ensino jurídico, quem a gente quer formar, para que a gente quer formar, a gente tem que pensar no ensino jurídico que consiga olhar para essas questões, refletir sobre essas questões. E isso é um caminho sem volta, né? Isso vem sendo feito nessa faculdade, sobretudo pelo trabalho do professor Juliano, né? E sobretudo pelo trabalho em conjunto, né? Essas atividades em grupo que permitem a reflexão, porque não se trata de simplesmente trazer verdades, mas de expor questões sobre as quais a gente não tem resposta ainda. Então a gente tem que pensar em respostas em conjunto, né? Isso vem sendo feito de forma revolucionária e de forma transversal. Nós comentávamos há pouco a importância, quando a gente fala de ensino jurídico e de produção de conhecimento jurídico, a importância de que isso seja feito de forma transversal, ou seja, não é mais a minha área, não é o meu departamento, não é a minha especialidade, mas é pensar no todo, né? Pensar conversando com outras áreas, com outros departamentos e com outros ramos do saber, porque senão a gente não anda, né? E é isso que vem sendo feito, é isso que a gente vai ver nesses 2 dias de simpósio, e é isso que dá orgulho à Faculdade de Direito. Então, aproveitando para parabenizar uma vez mais os 2 grupos, estou vendo aqui o Berardo, sempre aluno, a Jaine, a Melina, né, tantos membros aqui dos grupos, né, que se empenharam não só para organizar esse evento, mas para todas as atividades do grupo. Esses grupos dão orgulho à Faculdade de Direito, dão orgulho à Universidade de São Paulo, por isso eu fico muito, muito feliz de, na abertura desse evento, poder dar as boas-vindas a todos vocês, e eu só posso desejar muito sucesso nessa discussão, porque a gente precisa desse sucesso, né? É dessa discussão que vão sair resultados importantes para revolucionar a forma como o direito vai olhar e vai regular essas realidades. Parabéns, professor Juliano, parabéns, Berardo, parabéns aos 2 grupos e bom evento a todos.
Obrigado, Ana Elisa. Bernardo, você quer colocar algumas coisas?
Bom dia a todas e todos. Queria primeiro agradecer à faculdade por estar recebendo esse evento e por essas palavras. A gente tem feito muitos eventos e muitas iniciativas aqui na faculdade e ela tem sido sempre muito receptiva, tanto a professora Ana Elisa quanto o professor Celso Campilongo, em receber essas iniciativas e realmente fomentar e estarem presentes. Então, queria agradecer de coração por todo esse suporte, que é super importante para a gente poder desenvolver nossas atividades. E gostaria de dizer que nós teremos 2 dias, como a professora mencionou, de debates. Então, um primeiro dia de painéis e um segundo dia de apresentação de trabalhos que foram selecionados para a discussão. E convidar todos a acompanhar, seja presencialmente, seja pelo canal do YouTube, para que a gente possa realmente fomentar esse debate, né? Acho que é um momento muito importante da gente realmente discutir e ouvir as diferentes perspectivas para conseguir chegar aí num diálogo que nos leve a conclusões positivas em relação a mercados digitais, as questões de regulação de inteligência artificial. Então, eu queria agradecer tanto aos presentes que estão aqui presencialmente com a gente, quanto os que estão presentes online, e declarar aberto o nosso Second Digital Market Symposium, e nós vamos compor a mesa do primeiro painel, e daqui a pouco a gente já está de volta com a transmissão.
E os livros, não tem que falar alguma coisa? Amanhã? É porque a chuva atrapalhou, muita gente não veio por conta da chuva, tomara que amanhã não chova, porque nós vamos ter aqui alguns livros lançados pelo Instituto, que alguns nós vamos oferecer a todos, e outros são prêmios. Um é exatamente um estudo recente sobre mercados digitais e análise de impacto de regulações ex-ante para mercados digitais. Ok, obrigado.
Muito obrigado, professora. Oi, pessoal, bom dia.
Não sei se você vai
Estamos de volta
com...
Ah, perdão, claro. O microfone está longe de mim. Bom dia a todas e todos. Nós estamos de volta com o Second Digital Market Symposium para o nosso primeiro painel. Em razão da participação de professores convidados de fora do Brasil, do Christopher Yu especificamente, e nos próximos painéis, da mesma forma, nós faremos assim. O painel vai ser realizado em inglês, então eu vou mudar de idioma para que todos possam me entender. So, hi everyone. Due to the fact that we have international speakers, we'll be holding the panel in English. So for a brief introduction, this first panel is the ex-ante regulation in digital markets, and it will be a discussion with Bianca Mollicone from Legal Grounds Institute, Bruno Bastos Becker from Berardo Advogados. Both of them are here in person with me. And then we'll have also Christopher Yu, who's joining us online from University of Pennsylvania, and Lilian Marques from CADE. She was not able to do it in person, so we have a recording of her that we'll be playing first, so we have her inputs to the discussion. So with this brief introduction, I'll now play Lilian's video so we can start the topic on the ex-ante regulation in digital markets.
Morning, everyone. First, I would like to thank you for the invitation to be here today. Unfortunately, I won't be able to participate in person, but I was able to record this video and bring up a few points for contribute to the discussion alongside distinguished colleagues Bianca, Bruno, Christopher, and Berardo. It's impossible to discuss ex-ante regulation of digital markets without first mentioning the progress made, especially over the course of this year in Brazil. As many of you already know, this year, the Brazilian Ministry of Finance launched the public consultation about economic and competitive aspects of digital platform regulation, to which CADE, the Brazilian Competition Authority, submitted its contribution in April of this year. In this context, CADE advocates for the need for ex-ante regulation of digital markets, completing Brazil's antitrust legislation. Ex-ante competition regulation of platforms should address dysfunctions in digital ecosystems that affect the creation and appropriation of value. These dysfunctions are distinct from market failures found in traditional regulated sectors. Regulatory intervention should aim to promote competition by reducing barriers to entry and protecting the competitive process, ensuring market contestability. CADE has been consistently involved in digital markets over the past years, focused on both preventive and repressive actions, as well as on educational efforts. However, characteristics of these markets, such as network effects, can limit the effectiveness of interventions that rely on ex-post actions. Thus, complementing Brazil's competition law with an ex-ante regulatory model allows for the structuring of more proactive interventions, overcoming the design and implementation challenges observed in applying traditional antitrust remedies in digital contexts. This regulatory framework should promote consumer protection, innovation, and entrepreneurship while ensuring the preservation of market dynamism and enhancing contestability in digital economy. We know that there are various regulatory models, but how should we choose which one to apply? As there is no one-size-fits-all ex-ante regulation model for digital platforms, it's important to weigh the pros and cons of a more flexible versus a more strict regulatory intervention. In its response, CADE proposed that a flexible regulatory framework with individual adjustments and continuous monitoring could be beneficial for Brazil. However, before publishing a new regulatory agency, it's crucial to conduct an intensive regulatory impact assessment. Expanding CADE's competences by creating a dedicated unit for digital markets could be a pragmatic and fitting approach. CADE already has expertise in analyzing competition issues within the digital economy, and it also has the advantage of acting across various areas of the economy, unlike sector-specific regulatory agencies. Moreover, engagement with international jurisdictions and participation in global competition policy forums further supports the feasibility of this approach. After compiling and analyzing the various contributions received, including CADE's, the Ministry of Finance published the final report in October, summarizing the conclusions of the public consultation. This report presents 12 proposals, divided into two groups. Group 1, proposals for legislative change, and Group 2, proposals for regulatory and interministerial decrees. The first group of proposals aims to strengthen the Brazilian system for competition defense, to address competition concerns more swiftly and effectively in digital markets, where competitive pressure is lacking. The goal is to capacitate CADE with more flexible and adaptable tools to handle such agents, expanding the range of available measures to deal with situations where traditional antitrust frameworks are less effective and the risk of harm to competition is higher. In short, the ministry proposes creating a new legal instrument that would allow the designation of economically significant agents in digital markets, based on both qualitative and quantitative criteria. Designated agents may be subject to procedure and transparency obligations upon designation at CADE's discretion. Such measures could include a prior notification of mergers and acquisition, as well as obligations to provide clear information about their services or products, and to notify users of any changes in terms of service, for example. Structurally, in order to complement CADE's existing capability, the creation of a specialized unit for digital markets within the agency is recommended. However, given the involvement of various regulatory bodies with sector-specific competences, it is extremely important to foster cooperation within agents such as Anatel, the telecommunication regulator, and ANPD, the Data Protection Authority, when technical or sector-specific issues are at play. Additionally, the continuous enhancement of CADE's analytical framework is crucial to identifying and assessing competitive risks, enabling the development of more appropriate theories of harm for competition risks associated with digital business models. There are also issues related to updating turnover criteria for merger notifications to focus on cases with greater potential for anti-competitive harm, as well as adjustments in procedures requirements, such as the inclusion of a new set of information for transactions involving digital markets. So, that is a general overview of the current debate on ex-ante regulation of digital markets in Brazil. I believe we are at the stage of potential changes, and it's important that we stay attentive and prepared for what lies ahead. Participating in events like today's is crucial for that. Thank you very much.
I'd like to thank Lilia for her video and for being able to share her perspective with us. And we'll now hear the opening remarks of Professor Christopher Yu.
Well, thank you very much for inviting me to join you. I'm sorry I cannot be there in person. Can you hear me well? Great. So I'm delighted to have a chance to discuss issues around ex-ante regulation at such a critical time for Brazil, where you are confronting a major policy decision about whether to adopt such ex-ante regulations and whether that's the right path for digital markets going forward. One of the things that I would encourage everyone to do is to learn from two things. One, from the history or the scholarly literature examining when ex-ante regulation is the right approach. And in addition, I would encourage Brazil to learn from the ongoing attempts to implement ex-ante regulation and to see what they can learn from the early attempts so they can decide whether it's an appropriate move for Brazil, and even if so, how best to do it. Starting first on the theoretical aspects about the frameworks that help guide when to use ex-ante regulation, this is influenced by sort of two literatures in legal scholarship. One is the competition law principle of when you use per se illegality instead of the rule of reason. And the second is a well-established literature on what we call rules versus standards. A classic rule would be drive no faster than 100 kilometers per hour. A standard would be drive safely, reasonably under the circumstances. And you can look at the contrast, and we know from law that we use both forms over the longest period. And then the question is, when is each one the right form? And so that, I think, can really inform the decision to make ex-ante regulation. Well, distilling what those two literatures into a series of principles, one of the principles is that you use, one of the big advantages of ex-ante regulation is to basically minimize enforcement costs. So for example, if it's drive no faster than 100 kilometers per hour, adjudications are very simple and short. You simply use the evidence of the speed, and that ends the inquiry. And basically, it has the advantage of reducing litigation costs. But rules, by their nature, have a certain clumsy aspect to them. So for example, another classic rule in the United States, people start to vote when they turn 18 years old. Now, the problem with this is anytime you rules draw clear lines. Whenever you draw a line, there are people situated on either side of the line who are essentially no different. So there's someone out there who is 17 years, 364 days old. They can't vote. And you could say, well, what's the difference? Well, the answer has to be this rough and ready guide, the reduction in cost of determining who's properly prepared to vote is the reduction in determining that on a case-by-case basis is better than the rough injustice done to this person who's 1 day short of 18 years old. So you have to have rules that are well drawn, that draw distinctions that matter and that are well taken. And so this only, the way it often is said in the literature is that rules are cheap to write but expensive to enforce. Be reasonable is very cheap to write, but then you have to have a case-by-case determination to determine when to enforce it. Rules are expensive to write, but cheap to enforce. Now, what is the trade-off inherent in this? If you're only going to enforce it once in a while, the leverage of doing that work up front to apply to a lot of cases just doesn't apply. And so if it's going to be only done under a handful of cases, you're going to have to engage. You're not going to get any major economic reductions in enforcement cost on balance. The second aspect of this, which is interesting, is you have to be able to draw lines that actually make good enforcement rules. So for that, you have to have a lot of experience with the subject matter, and you have to understand it very well. But you also have to draw lines so that the prohibited practices are almost always harmful, and that you don't actually then, you use an American phrase, throw the baby out with the bathwater, which is you don't want to throw the benefits out along with it. And so you have to have a very clear policy inference around the practices you're prohibiting, and that you should that they're harmful. But in addition, you have to have products that are relatively uniform, because otherwise it becomes very difficult to evaluate. The environment has to be relatively stable. The internal innovation within the industry has to not be undergoing constant change, in which case, if it is, rules will be constantly going obsolete. But in addition, it's not just the internal environment of the industry, but the external economic environment has to be relatively stable as well for the rules, the lines you're drawing to be relatively sensible over a long enough period of time to make it worthwhile. And so what you will see then, for example, is the drive no faster than 100 kilometers per hour is a fairly robust and stable environment in terms of, car technologies haven't changed a great deal. The business environment hasn't changed a great deal. And we can see that where the context in which those sorts of things make sense. Now, what's interesting is to then take that basic framework and apply it to the Brazilian context. And particularly, I have in mind the proposal by the Ministry of Finance. I confess I've only seen summaries in English because I do not read Portuguese. But so I correct any misapprehensions I may have about the proposal. But what's interesting to me is that I'm not sure I would characterize it as ex-ante regulation. As an initial matter, a great deal of the determinations are done on a case-by-case basis. And so much of the leverage is not going to come from the kinds of clear guidance of permitted versus unpermitted activities. And so you end up with having, it's going to look a lot like adjudication in the sense that we're going to have to do it on a case-by-case basis. I think sort of the virtues of it, the thing that makes it not very rule-like is unlike, say, the Digital Markets Act from Europe, which has rigid numerical thresholds that cause for essentially presumptive liability. The Brazilian proposal talks about a qualitative multi-factor assessment, which is really more the hallmark of case-by-case evaluation. And what's striking to me is the things that are included in that, the considerations included in that mix, tend to be ambiguous. It's not the kind of clear, we can prohibit this practice without knowing, with confidence that we're not hurting consumers. So for example, the empirical literature is one of the factors is the level of vertical integration. The empirical literature is very clear that vertical integration is ambiguous and that in most of the cases, it's beneficial to consumers, not harmful. And I'm happy to review that literature. So as a consideration in the mix, it's fine, but if anything, it's ambiguous at best and tending towards good for consumers. And so using that as a major factor to prohibit or to impose liability doesn't necessarily make a lot of sense. Network effects is another thing that's mentioned. It's often assumed that network effects lead to winner-take-all markets. If you actually read the literature, both theoretical and empirical, that's just not the case. In the sense, it's ambiguous. Sometimes they do, but sometimes they don't. And therefore, you really need a more case-by-case approach to understand if this is one of the cases in which it leads to problems or which it doesn't. Access to data, offering the multiple services, again, quite ambiguous. But the thing that concerns me is there are two numerical thresholds based on the number of users and revenue. And this is sort of dialed back to the days of structuralism from the 1950s and 60s from competition policy globally, which we've largely abandoned because we realize they're very bad indicators. In addition, the determination of remedies, I think the fact they're not automatic is actually a good thing for the proposal because it doesn't fall into the trap of the European DMA, where liability automatically imposes at least a dozen remedies, which automatically, not all of which are well suited to the problem being solved. And so applying remedies are traditionally tailored to the harm, but when you have 12 automatic remedies, you can't do that. On the other hand, it does make it more case by case and less ex ante, because then you have to go through and craft those remedies. And the last comment I'll make is I think all of this conversation should take into account the recent report Europe released in the European Commission by Mario Draghi, the former head of the European Central Bank, former Prime Minister of Italy, was charged with really writing a report on European competitiveness, and was one of 2 highly anticipated reports in Europe. And it actually raised a number of flags about European competitiveness, how it's lagging far behind that of the US, and they're very much concerned about the lack of innovation going on in Europe. And the reason I would say the report's been extraordinarily well received in Europe, and in fact, the shift towards competitiveness is one of the cornerstones of President von der Leyen's second term as president of the European Commission. So she very much welcomed this report and is embracing its findings. One of the findings is a cautionary note about a precautionary ex-ante regulation, which it says it puts you in a position where instead of the default, it really hurts innovation, because instead of the default answer being yes unless proven harmful, you risk the default answer being no unless proven beneficial. And if the ex-ante regulation is designed badly, it can create effectively a presumption against innovation, which the report flatly admits needs to be changed in Europe. They think that, in fact, the over-reliance on ex-ante regulation is reducing European competitiveness, reducing European productivity and innovation in ways that they find quite problematic. And so that's the concern. And I would say that there's a lesson there for other jurisdictions like Brazil that are considering whether to follow Europe's lead and adopt ex-ante regulation as well. Thank you.
Thank you very much, Christopher, for your remarks. We'll now turn to Bianca Mollicone for her opening remarks.
Hi, everybody. It's a great pleasure to be here with you today. I really thank the invitation from Legal Grounds Institute and from Lawgortihm. It's a pleasure to be in this table with Professor Christopher Yu, Bruno, Becker, and Lilian, and also Berardo. The matter that we are discussing in this table is really effervescent in the world today. Actually, when you think that the platforms economy and digital ecosystems have undoubtedly brought many challenges in the field of competition, and digital platforms often act as gatekeepers. I think it's a kind of a consensus, influencing market access, competition, and innovation. And this raises, for sure, questions about fairness and consumer welfare in the digital age. And we see an ongoing regulatory race, actually, seeking for asymmetric antitrust model with ex-ante rules. This ex-ante regulation aims to impose proactive rules to govern market power, especially in digital platforms, to prevent anti-competitive practices before harm occurs, as Professor Yu has said, and Lilian. However, when you think about Brazil and other countries, we see Europe has DMA, in America they discuss the ICO, that is the Congress, and it's not with any pace to be voted. But we must reflect that each country has its internal realities to better assess how regulation can effectively contribute to increasing competition and consumer welfare without just resorting to imported models designed for other contexts. And when we see DMA, it has a context in Europe, why they have a legislation such like DMA. It was not just a matter of an accident. Yes, it has a huge context about American big techs in Europe and competition in Europe. We see the drug report on competition, and a lot of worries about competition in European Union in digital markets. So when you think about regulation in digital markets, first things to consider is dynamic competition. in the digital economy, particularly in relation to the big economic agents. I don't think that this concept has been taken into account when we see in recent ex-ante regulatory efforts, such as the European Digital Markets Act, the DMA, the UK's Digital Markets Competition and Consumer Bill. So the challenge is how regulation can strike a balance between fostering innovation and ensuring fair competition. And for this, we have to think about how big tech operates. Traditional competition models, which we call in economics static models, focus on short-term metrics like price reduction and market share. However, this approach doesn't fully capture the way companies like Google, Apple, or Amazon succeed. These firms thrive on what's known as dynamic competition, a paradigm that emphasizes continuous innovation, agility, and long-term differentiation. It's not new in economics. We have workers from post-Schumpeterian academics in the 70s, the 80s. So we have to really emphasize the importance of innovation in the digital economy. Innovation is a crucial driver of competition, just as a competition is a driver of innovation. The dynamics of competition in digital industries are driven by products that are not direct substitutes, but that compete for demand in complex ways. We saw recently when generative AI's products shake the markets in the end of 2022. So we were discussing how to regulate with ex-ante regulation because we have the big techs and the competition was jeopardized. And then the market was really shaken with the new generative AI tools. So it's a proof that the digital economy is characterized by rapid and constant change. The distinction between static and dynamic competition will really help us to understand that markets are not static, but rather evolving. And this implies that competition policies must be flexible and adaptable, able to respond to new realities and challenge as they arise. So we must recognize the limitations of going back to a structural analysis in digital markets, as Professor Yo has emphasized. There is an over-reliance on traditional structural analysis, which often rely on market share and concentration metrics. Certainly, these analyses do not adequately capture the potential and dynamic competition that occurs in digital markets. Competition policy needs to adapt to the complexity and to the evolving nature of competitions in these markets. And to do so, we need new tools and models that operationalize this sort of competition. And for this, it's really mandatory that we incorporate insights from areas such as evolutionary economics and behavioral theory. And what is dynamic competition? What is the big, huge difference in of dynamic competitions from static models? Dynamic competition is about much more than market share or pricing strategies. It focuses on innovation and their adaptability as key drivers for success. For example, firms rely on dynamic capabilities such as the ability to sense new opportunities, to seize them through innovation, and transform their business models to stay ahead in the market. The cycle of sensing, sizing, and transforming is really what keeps these firms competitive in fast-changing digital markets. As we see in evolutionary economics, it's a process. We have a path of learning, and the companies learn in the process, and they can innovate better because they follow a path, a trajectory of innovation. So we can think in this point in Schumpeterian rents that are rewards that companies earn by innovating and creating unique value. On the flip side, we must distinguish this from monopoly rents, which stem from anti-competitive practices like blocking competitors. While we should, of course, protect innovation rents, competition policies rightly aim to prevent monopoly rents. Big tech such as Google, Amazon, Facebook operate in this environment where innovation and adaptation are constant. Not only do they compete with similar products, but they also introduce new technologies and business models that can radically alter the market. We can come back to the example of generative AI. when you look from a dynamic competition perspective, we can recognize this reality, allowing for a more accurate analysis of how this company actually interacts and compete. For example, there's a lot of criticism on platform promoting its own products. We see in DMA that self-preferencing is forbidden in Brazil in some bills also. While this seems as harmful by some regulators, it's also a strategy that leverages scale to provide lowest prices and in some business faster delivery to consumers. So there's a huge importance of innovation for economic growth and improved consumer welfare. How competition policies can encourage innovations rather than stifle it with excessive regulations, as it may be the case in DMA. I don't know if you see recently in Europe, we have a lot of critics about, for example, hotel search that are not improving with DMA, but it's diminishing welfare, consumer welfare, and it's favoring like platforms, like big platforms, and not the hotels, the SMEs, etc. So how do we balance these approaches? Some academics advocate that we should integrate dynamic principles into ex-ante regulation. I don't know if it's actually possible. For instance, rather than banning all self-preferencing outright, regulators could allow it in cases where it demonstrably enhances innovations or consumer welfare. Similarly, the thresholds that we see in DMA, DMCC, the recent legislation from Australia that was enforced from yesterday, these thresholds for defining gatekeepers could account for market dynamics rather than only static metrics like revenue or user numbers as it is today. Another solution is adopting a hybrid regulatory approach, combining the clarity of ex-ante rules with the flexibility to adapt based on innovation-driven behaviors. Regulators could also focus on dynamic market assessments rather than rigid frameworks, ensuring that policies evolve alongside technological advances. So in conclusion, dynamic competition offers a powerful framework for understanding the success of big tech, highlighting innovation as a cornerstone of digital markets. The key is balance. And how is the discussion in Brazil? Lilian and Professor Yo talked about this. At this point, we have its first, the Bill 2768 from 2022, heavily inspired by the DMA. I'll be more flexible, assigning the National Telecommunications Agency the role of regulatory body. And this bill has been widely debated. It was the subject of a public consultation by the Chamber of Deputies last year. And this year, the topic was also addressed in a public call for contributions by the Ministry of Finance. And the results were presented in a report on October 10th. I won't comment the report because Lilian has already done so, and Professor Yo also. So I think we have an interesting point that I would like to stress. The report also recommends creating a specialized unit within CADE to monitor these digital markets, as Lilian has said. And another point is that it is to have the emphasis on seeking cooperation with other regulatory bodies such as Anatel and ANPD. It was part of an article that I co-authored last year with Professor Lucialina from the University State of Rio de Janeiro. We said that it's really important to create this interinstitutional cooperation between CADE and other federal agencies like Anatel, NPD, Senacom also because of the involvement of consumers in digital markets. And it was a suggestion in the report based on UK Digital Regulation Cooperation Forum. This proposal really addresses better the challenge to regulate digital market, but it is still focusing in some rigid thresholds. I think that regulation of digital markets is not just about controlling power, it's about fostering a digital ecosystem where innovation thrives along competition, and how Brazil can shape its digital future informed by global success and pitfalls. We have a very good debate ahead. I would like to listen for Bruno's contribution. Thank you.
Well, can you hear me all? Can you hear me, Professor? Yes? Good. Thank you, Bianca. Thank you, Professor Yu. Thank you, Lilian, for present your so it's not standing here. That's fine. It's good and bad to be the last one to talk because a lot of people like already presented on things I wanted to speak, but I see there's a lot of overlap. But before starting, I just want to thank Professor Juliano Maranhão, Berardo, Legal Grounds Institute, and Lawgortihm for the great invite. I'm very honored to be here in the symposium. Back to my second alma mater, did my PhD here, and it's great to be in this panel discussing ex-ante regulation. Well, first of all, everything is still in the very beginning, but it's also in the middle. Like, it's very hard for us to know where we are in terms of the development of platforms and technology. AI is coming now. We don't know where things are going. There could be in the next month a new technology that could, take over everything. So it's very hard to say. So the change is inevitable, as Thanos said, and uncertain. And the way I see this discussion here, it's not only on legal technique, but also on politics, a little bit of international trade, industrial policy, so the interplay of rules and regulations around the digital platforms. It's just not of legal technique. So like sometimes we try to be very technical here. The outcome is not that, pretty much that. I just want to cover 3 topics here. One is a little bit of what Bianca mentioned on this adjustment to realities, like how can we look into Brazil, into our reality, into our legal system, the way things actually work, not only on the books, but in the reality, a little bit of enforcement of regulation, and then a topic that I'm very fond of, which is the extraterritoriality, which is still a big question mark. But before that, I know I'm the last one, and I'm gonna say 2 very basic things here, but I just wanted to make sure we are on the same page. One is like the size of those giant companies. If you take into consideration user base, Facebook has, more than China population and India together. It's like they have 3 billion users globally, and India and China don't reach that. YouTube has 2.5 billion users. There's more than Africa and Europe together. In terms of GDP and market value, Apple and Amazon, they surpass many huge countries. So how does law interact with like companies that are bigger than huge states, and how do we impose decisions? How do we impose regulation on them, and how do they influence this kind of discussion and where we're getting to? So this is the first, before getting to the real topic. And then the second one is mentioning something that I haven't seen for a while. It's the general purpose technology theory. So we have this thing of general purpose technologies, and what are they? There are steam engines, electricity, internet, things that changed the economies, changed the world like forever, the way we do business. Internet did this. Digital platforms are doing this, and I think AI will do the same. But when we look in terms of time, how long it took. So for steam engine, it took 100 years to develop the technology. If we look at electricity, it took 60 years. Internet, 30 years. Platforms, 20. What about AI and the next technology? So everything is getting really much faster. So, and I say this because I'm not sure of which path is the best one to take when a change is certain, but direction is also uncertain. Like how do we do? That's a big question mark. So first of all, let's talk a little bit of ex-ante, ex-post regulation in this context of like our reality. And we're here all talking about innovation, right? Like how not to hinder innovation, what to do, which direction to go, not to promote innovation. But like we need to think also like a little bit in terms of like economy and politics of where are those companies, right? Like if we look into where they're located, like most of them are located in the U.S. There is a map in the report of the Brazilian report where they show where the big companies are coming from. The majority is coming from the U.S. So Brazil is mostly a taker, right? Like we take technologies and we need to handle them. So we are not benefiting that much in terms of economy, in terms of like producing wealth. The same for Europe. So like, it's very curious, and I'm an antitrust lawyer. If we compare like antitrust development, which started like 1990s, 80s, sorry, 130 years ago, the U.S. was the first mover. Now the U.S. it's taking a little bit longer to move and decide. It seems that they're going to this ex-post regulation, but everyone is looking to Europe, it's looking to Brazil, Australia, like all those countries that we are mentioning. So the US mostly exports platforms, right? So what is their interest, right? Like their interest is to keep innovating. Our interest is which one? It's like try to stop US innovation, or try to give space a little bit to our business. Maybe, I don't know, like what I'm saying here is like there's a lot of elements interplaying here that's not just the legal technique. And when we look into the goals, there is like a presentation by that's on YouTube by Professor Lazar Radic with Geoffrey Main, who is a good friend of mine. They investigated those goals across digital competition regulations, and they found that like the nature changes and vary a lot because everyone is taking very quick decisions. Of course, like we are in rush to decide where to go. We don't have much time because we see those big techs growing and developing, but without much control. Like there's not many decisions in Brazil and worldwide trying to stop them because everything takes too long. And when they're deciding, it's past already. Like they're deciding things that are like already not a thing anymore for us in our technology. And there's something I was like thinking. It's like there's not a good solution. I tried, professor, to find an expression in English to translate "se correr o bicho pega, se ficar o bicho come," which could be caught between a rock and a hard place, or damned if you do, damned if you don't. Which is like we are. I don't think there's going to be an ideal place here. But coming to Brazilian reality now and trying to understand what Bianca mentioned, I love Professor Mariana's gender perspective on studying Brazil and compared to other countries, but she tries to look in the good side of Brazil, right? Like the heterodoxy of Brazilian rules. And she's like, okay, maybe the rules different from the US and Europe. We may, when we do comparative law, say, oh, there's no, limited liability. There is not this, there is not that. But at the end of the day, there are some rules in other ways that protect us. So what I try to say here is like we need to understand how things work in Brazil. So if you look into how legal systems work, you have US, common law, blah, 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 decision-making process. UK, it's basically the same, but principles, and they're developing principles there. They're developing rules there. Europe, you have ex-ante rules. What do we have in Brazil? It's a huge mix with huge laws, huge constitutions. So we are a country where we regulate. Would we work with principles? I don't think so. Would we work well with ex-post decisions? I don't think so either, because decision makers try to look into the legislations to understand how to regulate. So there would be a huge issue, as I see in antitrust, if, let's say, CADE tries to decide on something that's not well regulated in the law, which is not. And then they will go to courts and higher courts, and at the end of the day, everything will turn into pizza, as we say in Brazil. Like we wouldn't have anything. So this is to say that I believe that we need to look into Brazil, and in Brazil, my opinion is that we not only like, but we need somehow to regulate. There's a path we have been following that's very hard to change and say like let's just do ex-post regulation. Then there's the second topic, which is the enforcement, how to enforce things. And enforcement in Brazil is also like a huge issue. Oh, how would we have a decision? It would take forever. As Professor, you mentioned, the cost of ex-ante is higher cost of regulating than lower cost of enforcing. In Brazil, we have a huge issue of enforcement, Professor. So the judiciary just decided, like, I don't know how long was the Nestle case, the 20, 30 years, like, it was really long. So this is like a 20-year long lawsuit in antitrust, can you imagine in the platforms where would we be in 20 years, like in Mars? I don't know. Like it's hard to understand, because if we look into the enforcement, it doesn't work that well. So like, enforcing ex post, I believe, would be even harder. And then you have the interplay of the platforms, as we mentioned, the power that they have. How do they influence decisions? How much money are they investing on building policies here in Brazil? How would we, have at the end of the day a lawsuit, let's say a lawsuit against a platform with ex post rules that are not legislated in Brazil, which is a thing, and work into that. So there is this whole, issue of enforcement and rules that, like, I'm a bit skeptical. I try to see, like, I think things work in Brazil. I love Brazil, and I just came back to Brazil because I love it. But I really think that our system works. Our system just does not work in the same way, the same fashion as other jurisdictions. So we need to look into our reality to be able to apply it well. And I do believe in taking this into consideration, that the report does a really good job on understanding how CADE works. How could we develop this, making a mix of ex-ante and ex-post regulation. Final words, I know I'm almost out of time. Just talking a little bit about enforcement, about extraterritoriality. This has been an issue in antitrust forever. Antitrust laws apply in an extraterritorial fashion. So if you're in the U.S., a company in the U.S., but they do a cartel abroad, there's effects in the country, and I'm simplifying really in a really bad way. But in antitrust, you do apply extraterritorial rules and laws, beyond the countries. There is a report that was just out in October by OECD, and one of the chapters they cover this, and I was very intrigued by looking to the results, because different from what you would expect from antitrust, this extraterritorial approach, in this digital markets here, it seems that the jurisdictions are having a very specific tailored approach to the countries, to the jurisdiction, to the borders. There seems to be a convergency of rules among countries and the EU, and it's a G7 report, so they cover 7 countries only. There is some efficiency considerations. They do mention global changes where, like, locally they propose changes, a body propose changes, and the gatekeepers change globally, like Microsoft just unbundled Teams after the EU investigation. There's also a Google privacy sandbox example. But I was very curious to understand how they interplay. But at the end of the day, we have hundreds in antitrust, hundreds of countries with antitrust regulation. There, you do have some convergence on the goals. Here, it seems that we don't. As I mentioned before, there is the study where Professor Main and Professor Lazar, they looked into the nature and the purposes, and they change and they vary substantially, very broadly. So my concern is here, how are we going to look into the future where all those companies are global, where companies like more powerful than most countries? What if there's this bad decision that they don't want to follow? Are they going to leave? We just had this Twitter example in Brazil in the Supreme Court. Well, Brazil, we do have an advantage now that even though we are, developing country, we don't have that much economic power. We have a lot of users, and they cannot disregard us. So this is a change in the politics of global politics, where Brazil, interestingly, start to play a more important role than in antitrust, because now the companies, they need us and they depend on us. So how are we going to regulate may also drive other countries. So I spoke already a lot, but again, thank you so much for the invite. It was a pleasure.
Thank you very much, both Bruno and Bianca, for your initial remarks. I think that one topic that we all touched upon was the fact that regulation needs to look at the reality of what we're actually regulating in Brazil, that it doesn't doesn't really matter. I mean, it matters as in the aspect that you should look at what other countries are doing, but that's not necessarily the lead that we should follow. I mean, we should look at their examples, what are their downfalls, and what are the points that they succeeded, and try to adapt that to Brazil. And I think that the point that Bruno brought, that it's not just a legal issue, and I think it kind of underlies with all the speakers, but the fact that it's not just a legal issue, but what we're actually inducing is very critical here when we're discussing how the law will interact with the companies. Because, for instance, the fact that we're looking at digital market regulations, DMA specifically in Europe, and all gatekeepers chose to do jurisdiction compliance and not spill that over to other countries, as they did, for instance, with data privacy years before. I think that speaks a lot of what is probably going to be induced as a matter of regulation, and we should look at how these regulations are actually impacting the behavior not only of other countries, but also of these sad companies that are the ones being mostly impacted by that. But the question I think I wanted to pose to the panel, and of course to Christopher, but not Lilian, she's not here, is how you see the fact that we're looking so much at DMA and the conflict that the decisions that could be made based on this DMA-like regulation has with CADE's perspective. Because, I mean, if we're talking regulation in Brazil should be looking at how Brazil works, then the bills should be looking at probably CADE's practice, of course informed by international standards, but looking first at CADE's practice to try to distill that, and then looking at what international standards are, what is the trend internationally, and how to implement that and make a juxtaposition that can work with both areas. So I think my question is, how do you see that potential conflict, and if you find any viable solutions for that?
Well, I'm happy to speak first if that'd be helpful.
Yes,
So,
sure.
Go for it.
I think that the question you're asking of how to do to follow the lead, to build on the points that both Bianca and Bruno made, I think Bruno emphasizes correctly, the Brazilian reality is very different. I mean, Mercado Libre is a bigger company than Amazon, and sort of the traditional concerns that they have just don't apply. I mean, Brazil has a vibrant fintech, startups. It's just a very different world than what you see in Europe, where you really don't even see these sorts of things. So I do think that there is a need to customize to what you're doing. And in this respect, I actually would like to recommend what Japan did. Instead of, what we see in Europe, they have designated 6 platforms as essentially subject to regulation. What Japan did is they did industry studies for all 6 and only chose to proceed with 1, which is the mobile operating systems. And it's understanding which are problematic in the particular environment is absolutely critical. On the other hand, I will say every country is unique, but there are some things, some general realities you can learn and draw from other examples. For example, the biggest one to me, as mentioned earlier by Bianca, is self-preferencing. A blanket prohibition on self-preferencing for large platforms could be quite harmful. So my colleague, Herb Hovenkamp, who's the author of the major treatise in antitrust, has a short article on self-preferencing where he focuses on the fact that Elizabeth Warren was complaining about batteries. The batteries we use, the electric batteries to power small, appliances. And the point he held up a battery and said that batteries in the US have the highest price cost margins of almost any consumer good. And that preferencing private label batteries can actually be incredibly beneficial. Bruno mentioned GPTs. And if you read the original article on general purpose technologies by Tim Bresnahan and Trachtenberg, the point they make is that general purpose technologies create benefits for complementary services. That is, it creates positive externalities that they don't internalize. And their concern is that there would be an underinvestment in platforms. And their solution was to allow greater vertical integration between the platform and the complementers of the offers the complementary services. So you see this very complicated reality, which needs to be studied and not just assumed that self-preferencing or GPTs just invoking these concepts leads to very simple inferences. Lastly, I would focus on what Bianca said about the early experience in Europe, which is the early returns. It's not only hurting SMEs. Google search has had to abandon putting maps on its results, had to imagine putting other things because of the non-self-preferencing bars. And there's evidence that entrepreneurs are abandoning Europe just because it's getting too hard. And what I would say is, at a time when Europe is turning away from an ex-ante regulation approach, I would say that there's some urgency, but there is some time to at least learn from what they're doing and see what their in the world experience is. And I wouldn't be in such a rush to imitate them right now, just because I think Brazil has an excellent chance to learn from what they're doing, what the UK is doing in DMCCA, what Germany is doing with Section 19A. And just by waiting a little while, you'll actually learn a tremendous amount.
Well, first of all, thank you, Professor, for commenting on some of the topics I brought up, and I really appreciate what you mentioned. And just to be clear, I'm not here trying to convince anyone to forget everything, but just to take into consideration a little bit of our reality. Going to Bernardo's point on the DMA and the report, I think that the report was did really well on not focusing that much on DMA. Actually, they very briefly mention it, but they don't use it as a strong resource to compare. On the contrary, they try to look into the CADE structure, into how our antitrust regulation works, how CADE works internally, how the tribunal interplays with the superintendents general. And that's why I think it was a win for them, not focusing too much on the DMA and trying to import, as we did a lot in the past.
It's the example that Lilian brought, having a specialized.
Yes, exactly. As we did a lot in the past. In the past, Brazil tried, as the underdog, tried to look abroad and say, hey, let's just incorporate things here. And I think that was like, when I first saw it, I was like, wow, this is great. Like they are incorporating like Brazilian culture, Brazilian legal structure, Brazilian CADE structure, and developing in a very unique local way.
I think that we have we evolved with the report of the Ministry of Finance, and the Ministry of Finance is really worried about Brazilian competitiveness, and this is the focus. Sometimes I think that maybe we should, we are so focused on antitrust, maybe we should focus on competition policy, really, because maybe this is the problem. But I would like to remark, Bruno, something that you said, that in Brazil, we are really, based on rules, and so it would be difficult if we are more open to standards than rules in competition matters. But we have to remember that, for example, in tax, that we have a strictly legal system. In criminal matters, we just spend 30 years to decide things. I used it to work in tax with tax law, and sometimes when I see the discussions today, the things that we have discussed 30 years ago. So is this a solution? I think that's the mindset of Brazil. We have to change this mindset. I know this word is sometimes it's not a very good one, but I think that we have a huge problem because everything goes to the justice, to the courts, and it's not a matter of competition. I don't think that a more open legislation, a more flexible legislation would really make it worse. I have the exact opposite view. I think that if we have something like the DMA, we'll have more and more litigation. If it's hard, we'll be, but this is not exactly what the law has said. So we will still continue to litigate. I think it's a Brazilian perspective. And of course, it's a matter of digital sovereignty. When we think about DMA, when we think about the laws that Europe has been passing, I had seen today Since 2016, we had the GDPR, the e-privacy regulation, the geo-block regulation, the copyright directive, digital content directives, the EIDS, the AI liability, the Data Governance Act in 2022, the Digital Markets Act, the Digital Operational Resilience Act, the Digital Service Act, now in 2023 e-evidence package, the AI Act now in 2024. So Europe is passing a lot of regulations to digital markets, and then sometimes it has to come back. For example, when we see France strategy to digital intelligence, they say that they have to review some things in GDPR and in the competence of CNIL, because otherwise they won't develop good AI systems because of a lot of regulation. So I think that Brazil should take these lessons for us to really don't hinder innovation. And we have a very flourished market. For example, in financial and in fintechs, we are really creative. Brazil can have a really major role in Latin America. We have Mercado Livre, as Professor Yu says, that has a position like some enforcement against big techs, of course, because of its interests here. But they sell in Brazil more than Amazon, as Professor Yu stated. So it's all a matter of seeing its own interests. Everybody wants to focus on its own interests. I think we have to focus on competitiveness and in the consumer welfare in first place.
Thank you so much for the comments. And just to be clear, I meant the original bill versus what has been developed. So thank you for the correction in the premise of discussing the topic. And I think that one very important thing is what Bianca has said just now about consumer welfare, and it's also touched upon Christopher Yu's example of how Google had to take out maps from its search results as a matter of compliance. So I wanted you to touch upon a little bit on how this impact on consumer welfare should be looked into, because I mean, we're used to some of the facilities that we have. For instance, when I search on Google and it's going to pop up a map, it's going to pop up ratings, it's going to make people's lives easier. But at the same time, there's the flip argument that says, well, Google is doing all that and it's just closing the possibility of other companies being developed and actually accessing this market. So I wanted to touch a little bit upon this this weighting, really, because when we look at EU regulation, it's a lot about consumer welfare. That's a lot on the reasoning behind the regulation. But at the same time, as all of you have mentioned, it's not necessarily the most conducive of innovation, and it's actually becoming a tech importer as well. If we look at the big tech companies, they're usually not in Europe. We have like Spotify that was made there, but other than that, it's not really a huge place, and it's not somewhere we see a lot of up and coming tech companies. And with AI, it's a lot of spurt. Even here in Brazil, we have a lot of legal techs investing on that, and it's not necessarily the same thing for Europe. So I wanted you to touch a little bit on how this consumer welfare also can, thinking about the regulation can be impacted.
Well, I'm gonna try. There's a lot like within exactly. There's a lot within your question. Like first thing that I thought was Brazilians love innovation and Brazilians love new technologies. We used, Professor, we used other platforms that never, were a thing in the U.S. WhatsApp, if we go back to Orkut and many other platforms. So I do like to think, thinking about Brazil, like that whatever new comes up, we will adopt it and we will take advantage of it. Sure.
Sorry about that, Bruno. Christopher's going to have to leave us in 3 minutes sharp, so I just wanted to give him the final 3 minutes of his time so he can share a bit of his perspective, then we go back to Bruno.
Well, thank you very much. I'm sorry to interrupt. I'm back to back with meetings, but what I wanted to, I agree that Brazilians love innovation. And in fact, innovation is the future. Focus too much. I think I want to go back to something Bianca said. It's not just about reallocating the resources we have today. It's about using them better. It's not moving, an economist would say, it's not moving along the possibility frontier. It's pushing it out. Now, one of the things that we have to worry about there, though, is when you have an innovation, often in the short run, the person who is the innovator will have a monopoly. And in fact, we have to look at this in a more dynamic, longer-term, robust way. Because the first mover, by definition, the person who comes up with a great new idea is often in that position. And so we need to think about whether there's entry barrier. And in fact, anyone who knows Economics 101, what happens is some change in the market that causes a shift that often allows people to earn extra money. That is an important positive thing, because that's what induces other people to invest, to expand their operations, to compete with them. And it's the desire to compete for that extra pot of money that really drives things forward. And so I'm always thinking about in the Hovenkamp treatise, when they talk about the essential facilities doctrine, which is a more static version of these sort of entrenched monopolies, he cautions against taking a too short-term perspective, because they said if it's going to take, entry is going to take a long time and may be very expensive, that can't be enough. Because if you grant access to the existing facility, you'll never get the competitive entrant, because why buy from someone new or invest in someone new and take the risks when you can just get it from the existing platform? What you can start to see is, in that world, what he would say, late and expensive is not enough, because late is better than never. And never is what you get sometimes when you throttle, if you provide access to the existing platform, because why would anyone invest in a competitive one? And so I think that there's a cautionary note where we have to take really a system whole perspective to understand what the likely impact of these interventions are going to be. And that's the end of my remarks.
Thank you so much, Professor Yu. Thank you for your words and for the panel. And I want to take a little bit on the essential facilities doctrine that you mentioned, because I had it here and I didn't mention because it was already too long what I said. I completely agree with you. Even and in the beginning, people were trying to fit platforms within the essential facility doctrine. It was a huge mess, and everyone was like, no, don't. It's just very different. And then they started developing these new theories on the ecosystems and the platforms. But what you have, and going also to general purpose technologies and also thinking about essential facility, the difference here for me is that the technologies, and if you look into essential facilities, they had a different nature, which is now those technologies are owned by a specific company, and they monopolize it, and they change over time. That's why most of the regulations are concerned not only on competition itself, the antitrust, but the incumbents protection, because that's at the end of the day what you need. What you mentioned on essential facility, let's wait and have someone new. It's better someone new taking a long time than ever. And that's what was my point to Bernardo's comment on the consumer welfare. At the end of the day, this is the thing. Yeah, you will have like some questionable decisions, like you had with the Google Maps and the hotels and everything else. You may have some good ones, of course. And now we are starting to deal with this changing nature of things, how to regulate, how to be able to create space for incumbents, but also reducing sometimes a little bit of the consumer welfare in that situation, because you want new companies to come in, and it's hard. Like I don't have an answer, because of course, like in the prima facie, like sometimes you will have some changes that will affect some consumers, reducing their welfare, but you also need to somehow leave and create space open for new technologies. Look into Brazil again. We love new technologies. So like, if we don't see them, we are never going to be able to use and make them a new platform. I don't know if Bianca, you have like something to add.
Well, when I studied economics about almost 30 years ago, we studied in industrial organization a lot of economics and in oligopolies, market structures in oligopolies, and a lot of evolutionary economics. And it's funny that 30 years after, sometimes when I see the discussions in antitrust, it seems like I am in the 1950s, 1960s, because it's still there. It's funny because I think sometimes people just don't read about that. This thing is, nothing. It's funny. And I think that antitrust today has a huge problem that sometimes we think that we will solve inequality problems with antitrust. And I don't think it's a good path, because who will pay this bill? The consumer. We have to make innovation flourish, and we have to think about the small competitors. But if they are really able to compete, because otherwise we will come back to the beginning of the end of the 18th century, think that we have to protect small competitors and not the competition. So I think that inequality is really a huge problem, but maybe the tax system is a better way to solve this. We have the BEPS initiative of OCDE, we have the Pillar 2 of minimum income tax to be applied worldwide. But I really think that to look at consumer welfare, we should still look case by case, even if it's not so easy. I think we have to solve the problem of taking so many times, especially in Brazil, as you addressed it, Bruno. I think it's a huge worry all over the world, but especially in Brazil. This problem is worst here. And for this, I think that the digital unit in CADE is really good, because you can have a learning path. You can be focused on things. Maybe we can have a more attentive eyes in the movements of the big techs, small movements even. Maybe not to take a decision right in that moment, but to learn how this dynamic competition work, how these markets works, and then studying these markets better maybe will make us solve the problems in a fast pace and to have a better results for the consumers.
I just want to comment back on something you were mentioned before, like the ex-ante, ex-post regulation, that we may want or need to try to do things differently, and in Brazil, because ex-ante rules don't work, let's try something different here. I don't know if I'm too skeptical or what is it, but we were like having a couple of months a discussion within IBRAC on the platforms, and then we were discussing, do we have the right tools or not? And some people said, yeah, we do. Some people said we don't in the panel. And then I loved what Professor Ragazzo mentioned. He was like, well, we don't have technical tools. Like, it's like economists or lawyers. Economists and lawyers then don't know technology. They don't know how to read technology. And we don't, the timing of things, right? Like you mentioned, ex-ante already takes too long. Yes, it does. I don't know how it would look in, the exposed. I think there would be no enforcement at all. The way I see things work in Brazil, and again, very unfortunately, things don't go further. Car wash, all the cases of car wash are going down, and at the end of the day, nothing is happening. I think that if we would have an ex-post regulation here, by decisions, but without like such a strong ground of rules in terms of ex-ante, nothing would happen. And then there's the question, like, do we actually need, because new companies are coming, but like thinking about the law and like we have an issue, let's decide either ex-ante, ex-post. I think both would be very, very bad to enforce, and with both we'll have issues. I just don't see our judiciary, and they won't change any sooner or ever, I don't see them, dealing well with like the exposed. I agree with you. We need to try to do something differently. Yes, we do. That's why I like so much the report that mixes both and tries to create specific rules for specific platforms, specific. They have different natures, right? Like Apple and Google and Amazon, they do different things. As the report shows, in that I love that map with the lines, they cross a lot. But yeah, we do need to look into them. I think maybe because we're slower, maybe we will have decisions from the US or from Europe and everyone else, like taking for granted that we are slower, and then our structure it's not as good or as qualified as other authorities, that we would perhaps just follow them and see how it works. But I agree with you, like ex-ante wouldn't lead to anything really good, perhaps faster, but would the ex-post do? That's the big question mark, right?
Thank you very much for the comments. And I think that the point of having CADE study the market throughout the time, it's very important, because as we talked here, tech is very fast paced. So if you're starting to take a look at how the structure is working now, then when you finish your study, then it's probably a little bit different, or very different. If we consider, for instance, if we started studying the digital market in 2021, then we have generative AI in 2022, and just changed a lot of the assumptions. And we are going to have a discussion on AI markets specifically, but I think it is capable to say that there is a lot. If we have a lot in digital markets to discuss, there's a lot in AI markets, a lot more to discuss, because I think the tech is harder. And I think it's a very important moment for everyone really to look into the technical aspects and how this is important for the regulation, because sometimes we're discussing standards and rules that are not necessarily applicable in the actual scheme of things when they actually are working. Sometimes it's not necessarily the best way of doing that. But one point that I wanted to highlight just is that when we're talking about the regulation, we also sometimes are going to be touching upon inadvertent effects. Like, for instance, one of the arguments that Apple has raised regarding giving access to their structure and for apps, etc., in Europe, is that it would compromise security. It's not that it's going to be non-security at all. It's going to be lifted, but it's going to be less of a standard of security as they would desire, and that they couldn't really deliver the same standard of security. So I think there's also a lot of the technical aspects to be discussed here. How different is the security going to be? Is it good enough for what we're seeing with data breaches and everything? Because if so, then maybe it is a compromise we're willing to make. But if not, then we should take a step back and be, well, there is this adverse effect that needs to be taken into consideration, because if I'm diminishing security and I'm causing more data breaches, then okay, I'm looking at antitrust and that's good, but what about all the personal information or company information that may be leaked from that? So I think that it also has to take on a lot of the technical aspects when we're looking into these type of regulations, regardless of its ex-ante or ex-post regulations. But definitely it's something for CADE and everyone that's really studying the matter to look at and be very aware of what the decisions are. So I just wanted to make this comment. If you have additional comments on that, please do. If not, I'll just ask for your final remarks before we finish the panel.
I'll comment with my final remarks. I think it's a very important point that you said, but the only problem is, where is the truth? It's really a technical problem or not. So in this case, I agree with Bruno. We need to we have to have the lawyers, the economists, and also the people from computer technology, because otherwise, and we lawyers, we economists, we need to know more about computer technology. It's not, we don't have how to navigate in digital markets without understanding what is behind. So when you say these things, again, we come back to the consumer welfare. We have to be focused on that. And what is important also, we have a very intertwined matters in this digital economy. So we have consumer data protection, AI, competition matters, and for that reason, it's really important to have an interdisciplinary approach, and also the agencies has to talk to each other. Otherwise, we have crazy, schizophrenic decisions for sure. Thank you, everybody. I love it to participate in this debate. I learned a lot with Bruno, with Professor Yu. It was a pleasure. Thanks again to Legal Grounds and to Lawgortihm.
Thank you, Bianca. Commenting on this. Lilian is not here, but I think if she were here, she would say that the report already mentions the council, the cooperation among authorities and agencies, which is like positive, and everyone involved in the report has been saying that the report is on competition of the platform, so they don't cover other areas, which is a huge problem, and we don't know yet like what's going to happen. I'm very curious. I believe that, I don't know, maybe having studied with Professor Faria here, it was be like you see things from the systemic view, and then, you know, like if you have a competition working well, then other areas would work. But you do have a point on data privacy. You could mention, like, because the platforms changed economy completely, you know, the way you work, the way companies are created. Nowadays it's more important for you to have a profile on Instagram than a name of your company, because what matters is for you to have the name, because everyone is bounded by this. Like, you do business now on the platforms, within the platforms, not outside. So, like, of course you'd have like labor law issues, even though CADE is more and more like getting into that area, but like, that's the question, because the report does not cover, and we don't know what is going to happen. But I hope, you know, I think that Lilian would have said that. On my behalf, I just want to thank also for the panel, for the invitation. Again, Berardo, Professor Juliano, Bianca, Professor Yu, and Lilian. It was a huge pleasure to be here, be back to USP and with you in this panel. Thank you.
Thank you very much, Bianca, Bruno, Professor Christopher, who has had to leave us a little bit earlier, and Lilian for all your comments, and we'll be back shortly at 2 p.m. Thank you.
Sorry for that interruption, but continuing, Christian Perrone is also associate researcher at the Center for Studies in Technology and Society at the University of San Andrés in Argentina. We also have with us online Paulo Furquim Azevedo, professor at Insper, where he coordinates the Center for Regulation and Democracy, and the Martinez Goldberg Chair, dedicated to economic analysis of law, and Juliana Domingues, professor of law at the University of São Paulo, and regional director of the Academic Society for Competition Law. We'll begin with individual presentations of around 10 minutes, and before we move to a debate and a Q&A with the audience. Morgan Reed, please, you may begin.
Do I have a microphone?
Yes, this one.
I made my stopwatch. Hello, everyone. My name is Morgan Reed. I am the president of the App Association, but I am also a recovering developer. I had the joy of working on several open source software products and projects in the world, and learned my first, did my first program in 6502 assembly language a million years ago, when many of you were. Activity that is done when there is market concentration that you believe is preventing innovation, then there is an opportunity for the government to step in and try to correct it. One of the most difficult issues with antitrust in the digital market space is that the rapid nature of change is so abrupt that it makes it incredibly hard for government officials to predict correctly. And the track record there is not always great. The reality is in most of the tech industry, what happens is it is a rush to what we call disintermediation, meaning removing barriers. For those of a certain age, you will recall that 10 to 15 years ago, to buy software, you would go to a store, you would buy a box, you would take that box home, you would put it into your computer, and you would then install the program. And this is important because for you, you just went to a store and bought a box. But for me as a developer, first I had to find a company that would be willing to represent me. I had to write a check for $20,000, $50,000 US to prepay for marketing. I would then buy magazine ads. Then I would have to contract with a company to make a box, to print a manual. Then I would have to negotiate with the stores. When you walk into a store, what you see on the shelf is not there because a manager said, oh, that looks interesting. It's on the shelf because I paid to be on the shelf. When you walk into a grocery store and you see products with nice displays on them, they paid to be there. We call that an end cap. So as a software developer, what you as a consumer saw was a box, you put it down, you plugged it in. What I saw as a developer is many things that I was not good at that cost me time and money. And so the revolution that happened, really, Apple and Google like to claim they were first, but in fact, BlackBerry had an app store before Apple and Microsoft did. We were getting near it. Microsoft had one, BlackBerry, but really Apple kind of pushed it forward. And it made an enormous change for us because I didn't have to print a box. I didn't have to negotiate a contract with a publisher. I didn't have to manage credit card bills. I didn't have to manage tariffs and taxes from around the world. And all of a sudden, with a click, I could have my software available to 162 countries the next day. And so all of that infrastructure and work that was underneath it was gone. And so that was a huge revolution for the development. And the hard part from an antitrust perspective is if you looked at the time 10 years ago, what was happening? Microsoft was under investigation. Intel was under investigation. Intel is now fired their CEO today, and they're down 61%. But 10 years ago, everyone was sure that Intel was a dominant monopolist who was taking over the world. There was a case in the United States, a case in Europe. So what you saw was rapid, huge shift in everything. And right now, we are watching kind of the same thing happen around AI. Intel may go out of business, may be bought by Qualcomm. NVIDIA, a company almost no one who didn't play computer games had talked about until 2 or 3 years ago, is now huge, biggest company in the world. Microsoft is no longer thought of as operating systems and office software. They're trying to compete in AI. Google is not where everyone else is yet on AI. And Apple is trying something completely different on AI. And if we had to guess, I would guess that we will see players like Xiaomi and Huawei coming in to play important roles in this AI fight that we're about to get in. And I want to wrap that up into the question that you started with is, so how does a government that by its nature moves slowly, must build credibility, must do reports, must do consideration, how do they take action in this space? The probable best thing that a government can do is look to establish clear rules of the road and mostly get out of the way. There are some examples where I think there is good cause for government action, and it's one that's very dear to my heart from the open source side, which is in standards. We're here in the law school in Sao Paulo, and one of the important things that happens in standards is something called intellectual property. And if you think of it, in the standard space, if you build a technical standard, it should have inventive things in it. It's completely fine. And people should get paid for those inventive things. But what are the rules of the road for everyone else about taking a license for that? That's an example of a place where an antitrust agency, like Brazil's, can take a strong stand to say that anyone should be able to take a license to develop using a standard. So if you think of it this way, normally in intellectual property, if I invent something, I could say, Christian, you may not have it. It is only for me. But I think in standards, if I say, Christian, I am putting this into a standard that we all share, then I think that Christian should always be able to license it. Thank you, my friend. And so there is a difference because I think the government can play a role in establishing those rules. Now, as far as market concentration, I think that if government was good, if the people working in government were incredibly good at guessing what was going to happen next, they would be working in the stock market, probably not in government, because no one is sure what is happening next. We can see that in 5 years, the companies we all talked about that we are talking about now, 2 of them will probably be gone. 2 of them will probably not be famous. At least one of them will be the Intel of today. Intel, the biggest maker of chips in the world 7 years ago, 61% decrease in profits, now being sold off for parts. If I were to make a prediction, my prediction is in 5 to 7 years, 2 of the most famous companies you know of today will probably be in similar straits. And that is because the speed at which it happens. And I would leave you with one thought from the small side. Remember when I talked about the way that when you buy the software now, it has 3 parts to it that we need as developers from these platforms. We have 3 things that we always need from platforms. Number 1, we need the ability to offload overhead. Like I said, I need to not have to print a box. I need to not have to negotiate with a publisher. So I want to offload overhead. I want to do the things that I do well, write software, and get rid of the things that I do badly. And maybe I'm going to use cloud from Microsoft to do my product or from Amazon to do AWS, but I want to do the things I do well, and I want to use others to do the work that I don't want to focus on. That's number 1. What do the platforms provide to offload overhead? Number 2, I need to have a marketplace that has trust. And that is one of the most valuable things. And when you are considering antitrust law, it is what are the unintended consequences of tearing apart all of the companies, and what do you do to the trust framework? If you ask people where they get their apps right now, do they think twice about downloading from Google Play or from the Apple Store or from Microsoft Xbox? They don't. They say, well, I like that game. Click. But if you had 50 different stores with 50 different companies from around the world on your phone, and you're looking at each one and you're thinking about it, how does one rise up and to become the trusted company? Do you spend money? Do you do advertising? How do you build that brand of trust? because that's what we need. So when governments take action, be very careful not to destroy the trust framework that small companies rely on to be powerful. We need the trust of the brand names to be on top of it. And the third leg of the stool is what I would refer to as access to a global market. And it's fascinating to be in Sao Paulo today. You have 22 million people in this area. Brazil is the economic hub of Latin America. It pushes up and competes directly with Mexico all the way up past the border. You have the chance to reach, your people here have the chance to reach more customers, even though you speak Portuguese. You still reach more customers in Latin America than almost anyone else. So how do you make it easier for your developers from Brazil to have products available everywhere else? Argentina, Chile, everywhere else, Uruguay. How do you get it into the position where your developers have one click and they're in? So the three legs of the stool for us are very simple. Offload overhead, trust, and access to a global market. And so when you think about antitrust and the actions that governments want to take, what needs to be preserved are those elements, because those are the elements that allow small businesses to succeed and become big businesses. And so when I said in 5 to 7 years, 2 of the most famous companies will probably be no more or not so famous anymore, my hope is that one of my small members will end up being one of those names that we talk about. And the way that we do that is through healthy competition and having those stools of trust, offloading overhead, the ability to buy services, and then access to that global market. And I think that ends my time.
Thank you very much, Morgan, for this very insightful overview. I will now pass the floor to Christian Perrone.
Thank you very much, and I think it's a very interesting segue. I want to tell you that I'm not going to talk about competition per se. I actually want to talk to you about, I think I have some slides, if you could help me with that. So I want to talk to you about whales. I know you're going to say that I'm crazy, that makes no sense.
What kind of whales?
Well, that's a very interesting question. We can go down that road in a bit. But the interesting thing is that I have to tell you that I'm going to talk about whales, not because I'm a whale expert, which I'm definitely not a whale expert, but because, and I'm actually not, a competition law expert at all, but I am an expert on AI regulation. And then I'm going to use the example of whales to actually highlight and to showcase what it means to take a look at the market in terms of AI if we do not, if we're not very careful to a certain extent. So why we should look at markets as a way of understanding context, a way of understanding how the AI ecosystem works. So if you're talking about digital markets and we're talking about trying to regulate digital markets in a certain way, so how should we regulate digital markets? And particularly, how should we regulate the future of AI? And to be honest, I have to start with you talking about what AI can do for whales to a certain extent. So I know it's taking, a slight moment for us to see our slides, but the interesting part about talking about whales is that I want to really have in your minds that when we're talking about AI, we're not talking about one specific clear-cut market. First, AI is a technology that has general purpose, or you can say it's a general purpose technology, another GPT that doesn't have anything to do with ChatGPT, but it is an important technology. And what it means for looking at markets with this idea of looking at digital as a whole thing is that you miss the fact that when you're talking about this types of technology, we are talking actually about every single sector of the economy in a way. So yes, now we are saying about whales. So now I can go into that. So why talking about whales? So I want to talk not specifically about certain species of whales, but to talk about how do we manage to keep track of whales. Do you have any idea how complicated it is to keep track of whales? And why keeping track of whales? Why would it be in any way relevant to anyone, any market? Because of two things. Have you ever heard the importance of canaries for mining? So in the past, canaries were used to say there was a problem with the mine, there was air that was not as polluted, and then this was sort of a signal of what should we do. We should leave that mine or do something with it. Whales are the same for the ocean. So keeping track of whales helps us understand the whole sustainable aspects of whales and understand how the oceans actually are. But how to do that? So we've been doing it, I mean the world, and just to give you a hint, I'm a researcher on AI, not a researcher on whales. They've been doing for the last more than 50 years, particularly looking at image and trying to understand on that specific image, is that a whale or it's not? So use new satellites and getting better. So it's easier to understand whether this image refers to whale or not, and it goes on and on and on. Why not use AI? AI will help on where? AI will help first identify which images from satellites all over the world taking pictures of the huge swaths of the ocean, and to say, well, this is probably and very likely an image there is a whale. This is one system, one AI system that can be used. A second AI system is the one that you go down and then you classify. Well, this one that looks like a whale, that might be one species or another species of whale. And then you start to understand the population of whales in this way. But that is just a part of it. How do we do an actual solution that will help us count specifically whales, which types of whales, in which area they are? So can you go to the next slide? So we have to actually look that when you're designing an AI tool or an AI solution, we actually are using a value chain, or if you look at markets in other way, it's a supply chain that's not exactly as easy. Can you go to the next one? As the one that you would expect. It's not just 1, 2, 3. So developer, distributor, deployer, and final user. Actually, when you're talking about an AI market, you're talking about a very complex market. So you're not going to look at it as just, so let's look about the AI market worldwide. No, we have to look at AI solution for that market specifically. And this means about looking at a complex value chain that may involve many, many players. In that value chain that I mentioned about whales, we actually have the satellite provider, the image provider, the provider and developer of AI for identifying images, and another provider for classification of images. There is another one that will adjust that AI to specific whales. It can find one what it is the other. You have to have one that will look at from a human in the loop perspective of looking, well, is this correct? So do we have scientists to take a look at whether it is correct or not, or experts on whales, which, as again, we're not. And then in the end, you need a whole bunch of players and agents and participants in a very complex AI value chain. And this means as well that, can you go to the next one? That you actually has to look, when you look at a market to regulate in terms of competition or antitrust, you have to look at this market as more of a ecosystem of different players that are working in one hand cooperation, in another hand competition. It's not an easy track, like looking at a supply chain in a factory that is going to have a car in the end. But you have obviously also an ecosystem that's very siloed to supply specific elements for that particular brand and model of car. This is different. In AI, that very same system may be supplied by different competitors, might be assembled in many different ways, and might be used in a very broad ecosystem that actually, in most cases, is an open ecosystem, in a global ecosystem. So how you define the markets in terms of competition law, how do you define the specific solution, this is very contextual. So when you're talking about which types of methodologies you're going to use in terms of competition law, you have to remember that the AI ecosystem is very much different the others. As professor here on my right side said, if it is a prediction game, this mechanism of prediction is going to be very, very much complex because the market itself is complex and because the players are complex and because there's a huge dimensional, can you go to the next one? The dimensional stack of different players that will work in competition and in cooperation in many different aspects. So if you want to look at this from the perspective of competition, you have to look at from the perspective of context, but also a perspective of access. And this is something that we agree with. You have to have access to the different tools in order to build the different solutions of AI of the future. So remember, the tools from a technology that is of general purpose means that they will be able to participate in many, many different markets and may be used in many different things. So it is a matter of looking at the context itself and whether you have access to that tool or not, either by licensing or any other way, that you have to look at competition in a specific market, particularly if you're looking at AI in general. So this is my first remarks. Thank you. And remember, waivers are nice.
Thank you very much, Christian, for this very interesting and unexpected presentation. I will now ask Paulo Furquim to join us to start his presentation. Professor Paulo Furquim.
Thanks, Beatriz, and I also thank Juliano for the kind invitation to be in this session with you. I have also a presentation, so I'll share the presentation with you now. So just a moment. I think now you have it. And let's put in presentation mode. So I will try to answer that particular question that the organizer posed to me. You see that my presentation will be half economics. So the first half is pure economics, and the second half is competition law. As a preliminary remark, I would say that I entirely agree with Morgan's talk and that idea of uncertainty and the future is unpredictable. And the market power of today is not necessarily, sometimes even rarely, the market power of the future, of tomorrow. I will talk about the measurement or assessing market power today. And I acknowledge the limitations of measuring the market power today, endorsing Morgan's talk on that matter. So let's move ahead. So the idea is to have a general view of how economists, they assess market power in markets in general, and then in digital markets and platforms, we do have a way of measuring market power nowadays, but you see that measurement that they provided, I mean, the economic literature they provide to us is not useful for the purpose of enforcing competition law. I will try to make that clear in a moment. So how economists assess market power? There is this mainstream view. I will try to be very brief and synthetic here. So we use what is called the learner index. This is the most accepted measurement of market power. Is more commonly known as the markup. So allow me to put some equations here. This is one that is the essence of measuring market power. So you see in the upper part is price minus marginal cost and divided by price. So this index, if we have perfect competition, price equals marginal cost, so the upper part is 0. So this is the extreme of the index in terms of the more competition that's possible to have. And in the other extreme, we may have a very high price and a very low marginal cost, and this approach to 1. So the index go from 0 to 1. And oh, sorry. Thank you for I think I have to put in presentation mode before, maybe. Oh, I don't, we didn't rehearse that part, so I'm sorry about that. I think if I do exactly what I did, it will not work well. So, okay, so I cannot put in presentation mode, I guess. It's okay. So you see I was explaining how to measure market power. And then we have here there are several ways of measuring it, but the most common used by organization economists, which is the basis of antitrust economics, is to estimate demand. Where it's something that is important to mention is that we cannot really observe marginal costs inside firms. This is a private information by firms. We observe price. So we need to have an indirect way to measure the marginal cost. And this indirect way is measuring consumer behavior and the behavior of the firm pricing, seeing the demand. So it's the demand estimation, and we have the inverse of the price elasticity of demand as the measurement that normally we use. This is very complicated because it's not that easy to estimate the demand for all the products. Sometimes it's even impossible. You don't have the data for that. The other methodology, there are other methodologies. One that's really gaining momentum is to use production data. So this is a methodology introduced by Jan de Locker, and he is the guy who came up with the studies measuring the increase in markup in the US economy that trigger all the discussion about reforming competition policy in the US to have a more stricter competition policy. And as for digital markets, we have to take care of some particularities. If the market is only digital but is not a platform, we could use the learner index, but with some care because marginal costs tend to be 0. And if there is the slightest differentiation, the price will not be 0. And then the learner index will be 1. And it's not exactly the market power, the extreme of market power. So we have to be very careful in those situations. And in the case of multi-sided platforms, this was contribution by Rocher and Tirole, the idea of two-sided markets, and they came up with a much more complicated version of the learner index. We can call this the modified learner index. And here you see you have it's like a price for entering the platform. So it's similar to the learner index. This is the marginal cost, so it's similar. But now we have this term here. So this different additional complication here. You have to consider that there is not just one price. So the price in one side of the market has an effect on the number of consumers in the other side of the market. So we have to think about the prices in all the sides of the platform in order to have a measurement of market power. This is very complicated, and also this is very sensitive to choices, to methodological choices. Different models may come up with different measures of the market power. So, and what we take from that, and our question is how to assess market power in law enforcement. It's a completely different problem. We know that the problem of enforcing the law is not exactly the problem of blackboard economics. And we need to have some attributes for the measure of market power. First, it has to be practical with low enforcement costs. It's not the case of the measurements that we just saw. Easy to understand for companies, for other enforcers, also not the case of what we just saw. Also predictable and not so sensitive to modeling choices. And fourth, and this is important everywhere, but in Brazil is also very important, it has to be verifiable by the judiciary. So the final word may occur in the judiciary. So judges are expected to understand this measurement. So it's not the case of this modified learner index. So you have to come up with suggestions that at least share some or all of these attributes for measuring market power. And one of the directions, I think that's important to an additional remark, we don't need exactly a precise measurement. We need something that provide us with a binary classification. Dominant position, not a dominant position. It's different from having an index from 0 to 1, and then we have a continuous of market power. What we need is this binary classification. Extreme dominant position or not so extreme dominant position is not really the point. The point is dominant position. We may have turnover. It's not so appropriate for digital companies. We may have companies with immense value and no turnover or even no profits. Because they have a critical mass and people anticipate they will have, in the future, they will have profits. But the value of the company today is an expression of the future profits of that company. And this is something that is not in the turnover of a particular year. We may have the market share, but the market share trying to access this idea of if the company has surpassed the critical mass, then it has a dominant position. And also, and these are put with interrogation mark, it's like a question, is should we consider if the company is part of a dominant ecosystem, although the company at that moment, I mean, in the particular market, is not dominant, but is part of a dominant ecosystem. And this is my last slide, is a summary of what I observe the authorities are doing to assess market power. So take first CADE, so the Brazilian Competition Authority. I do not observe, maybe Juliana can contradict me and provide other examples, but I don't observe a specific measure, a consensual measure of market power so far for digital markets. But actually, in most of the cases, it was unnecessary because we need this binary classification. So does Google has a dominant position? This is not something that we need a learner index to be sure about that. It's really obvious. So part of the cases are, it's really obvious the dominant position, but sometimes we will need a predictable and very clear assessment of market power. In the case of the central bank, I think it's a benchmark in how to do that. In the experience in Brazil that they have, mainly with the tech fintechs. So they have a regulation that must be applied, well, stricter regulation that must be applied to companies that have dominant position. The companies that don't have dominant position, they do whatever they want. So this asymmetric regulation worked pretty well. In the case of payment platforms, it was separated by the volume of transactions. It's very clear, it's predictable, it's easy to explain to a judge. Of course, it's not exactly the measurement of market power as the economists would try to calculate, but it's something that is more useful and fit for the purpose of enforcing the law. And third, I think everyone here knows about the recommendations for digital platform regulation by the Ministry of Finance. So it's not really clear. They wanted to have this idea of asymmetric regulation and classifying companies with dominant position, no dominant position. Although not clear, my reading is that they are in the right direction. They are looking after some direct and simple assessment for ex-ante classification of companies in order to apply stricter regulation or not for those companies. So that's the end of my talk, and I thank you for your attention, and I will try to stop sharing.
Thank you very much, Professor Paulo. I will now yield the floor to Professor Juliana Domingues.
Thank you, Beatriz. First of all, I'd like to thank you for this kind invitation. It's a pleasure for me to share this panel with Professor Paulo Furquim, with Morgan, Christopher. Also, thank you, Juliano. I cannot see you, but I think you were here or there, right? I didn't prepare a presentation, and I will try to add some comments about the important questions for this discussion today. So I would like to share a little bit the Brazilian perspective. I think Professor Paulo started, but I think it is important to consider that here in Brazil, there is no over-enforcement related to digital markets or related to AI today, right? So according to CADE, 84% of the digital merger cases from 1995 until 2023, they were evaluated through the fast track proceeding in Brazil. So why I'm sharing this? I think it's important to talk a little bit about the basis of antitrust. That is the definition of the relevant market. I think the key challenge in digital mergers is defining the relevant markets. And the lack of precision can affect competition assessment. Narrowing or broadening market boundaries is crucial in determining market power and also concentration levels. And the novelty of certain business models along their ability to evolve into different industries and technologies in the same time, I think adds an extra complexity to the market definition and to competition analysis nowadays. And I was thinking here when I was listening to Christopher and Professor Paulo and also Morgan about one case. And for instance, I think it's important to share the Naspers Delivery Hero case from 2018. It was a case related to our online restaurant delivery segment. Was a new market to the Brazilian Competition Authority. And this require an analysis based on the market tests and projections regarding the potential entry of new competitors. And despite the approval, because the merger was approved by CADE, but CADE decided to monitor the acquiring parties' future transactions due to the uncertain dynamics of the market and their dominant position in the segment. And in the CADE's decision, the Brazilian antitrust authority adopted this dynamic approach rather than the traditional static perspective, right? So the authority was considering future and potential competition in its market assessment, right? So it was something new for us. And why I decided to mention this case here, because maybe we don't need new tools or a new law or a new coordination inside CADE to design good solution or solutions that will or at least can preserve the trust framework mentioned by Morgan Reed. I was thinking about it, right? And I think it's very important to preserve the environment for innovation, especially in Brazil, that is a developing country. Another point that I would like to highlight is something that Professor Paulo touched here. It was related to the Brazilian courts. Because after my experience as Attorney General at CADE, I really believe that we need to consider how the courts will interpret the agent's decisions. We currently have more cases being reviewed by the Brazilian courts, antitrust cases, than under investigation by CADE. Just to give you a picture, I'm talking about more than 500 CADE decisions, cases that were cleared by CADE, that are under review in different courts across Brazil. And unfortunately, the courts in Brazil, they don't have the technical expertise to handle regulation or antitrust matters. And I am sure they know more about whales than about AI, Christopher. And this raises concerns about how they will handle issues related to innovation and dynamic competition. I would like to ask this question. How do you think we can bridge this gap, especially being a developing country, right? This is the answer I am trying to develop with my current research. And another aspect to consider in our debate today, I think that CADE used to be a risk-averse when faced with multi-sided and dynamic industries, right? And many cases did not trigger concentration levels that attract antitrust review when agencies use traditional methodologies and to define the relevant market. So Paulo mentioned here what is new in Brazil. We have some proposals that were released by the Ministry of Finance. They prepare a theoretical analysis and comparative. The report is very deep, right? They base it, the whole report in more than 70 contributions and the benchmarking involving more than, I think, more than 10 jurisdictions. But one curious data that I would like to share, especially to Morgan, is that US was the country with the most significant number of participants based on the headquarters and head offices of the economic groups, right? So much more than Brazil. So given this picture, I think that the main topics that were highlighted in this document show some limits related to our antitrust law. I think it's important, right? Especially related to our analysis on mergers, and also the problem that we have with, very small companies being merged with big companies, problems in identifying market power, limitations related to the revenue criteria, right, and ex post review of mergers. I think one important thing is to think about the gaps in the antitrust practice in Brazil, difficulties incorporating and applying a new theories of harm, low application of preventive measures, low use of what we call here the residual jurisdiction to analyze mergers and to meet these revenue criteria that we have nowadays. So we have general problems, right, related to our system. We have costly investigations when we talk about innovation. We need to clarify these new theories of harm and, also think about these traditional methodologies that we have and apply them for platforms, for example. And of course, we have difficulties in design and monitoring remedies here in Brazil. So they propose they introduce some ideas related to new rules, that they want to bridge traditional antitrust law with economic regulation. But I think we have two main problems here. Do we have the budget to do it? And how can we develop capacity inside the authority now? So I would like to finish with those questions, and I would love to hear from my colleagues and the audience what they think about those topics. Thank you so much.
Thank you very much, Professor Juliana. I'm very curious to learn about your current research. In the previous panel, we discussed about ex-ante regulation, and some of the speakers mentioned a lot the need to assess the Brazilian reality, the Brazilian economy, and obviously the matter of not stifling innovation was very much talked about, but specifically the need to improve innovation for Brazilian firms, perhaps. So I would like to hear from you, considering also Morgan's framework, let's put it that way, about considering the need to provide trust and access to international markets. How do you see the need for considering the Brazilian reality to provide access to international markets and trust for also Brazilian companies? And how do you think our authorities are analyzing these issues, or what factors could they be considering in order to really adapt antitrust to the Brazilian reality? So whoever would like to start, thank you.
Well, first of all, we need to say that Juliana won the day. We could all leave now. Her whale comment, she wins. So you have won the entire session. We are all bowing down before you. But I think you asked the right question, which is, it's a very interesting thing, because I know you use the term developing nation. I think that you undersell Brazil's ability to impact Latin America, which is obviously one of the fastest growing regions. It's, as you know, we call it BRIC. Brazil is the first letter in BRIC. It is a developing, but I think that the resources that you have here are incredibly strong. And so I think that one of the things that you think about is on that trust framework. Juliana talked about it earlier, which is a vibrant judiciary where things are provable and substantiated by the judiciary. On mergers and acquisitions, I will tell you, it is something to be very careful of, because small businesses, the dream of the small business is maybe you go public, right? That's your dream. Maybe you become the next Google. But the reality is your chance for a liquidity event, your chance to make money is often through an acquisition. Christian was talking about the ecosystem. Well, if I do something better than anyone else, then someone's going to look to acquire me. And then I get bought, and then I do the next thing. Because here's the reality of a lot of small businesses. We're really good at some things, but we may not be good businessmen or good businesswomen. So you have to allow mergers and acquisitions to bring talent together. Because he showed that map of the ecosystem with all the fuzzy bunnies and everything else. Maybe I just have the worms in the soil that turn the soil, that make it healthy. Maybe that's what my product does. Maybe I am looking at the data sets in a new way. And I have invented an algorithm that looks at data sets to look at bias. And I have a better algorithm. I can't build a company to do all aspects of that, the silo, but I can get bought by someone, and then my change will have a substantial impact. So when you talk about how do you do it, I think it is important to having a healthy merger and acquisition system. I also think for Brazil, this is specific to Brazil, I think it's very important that Brazil not let China, probably as the biggest player, not let China dominate the standards space, because the reality is small businesses use standards to leapfrog, right? Microsoft or Apple or Google, they have enough money to build the entire thing. They can build the wheel, they can build the hub, they can build the tire. What I'd like to do is buy a standard tire and then build a car, or build something no one's even thought of that uses a wheel. So standards are a very important thing. And I think access to licensing in standards is something that will be very important for Brazil's reality, because you may not have the infrastructure to build every part of it, but a healthy standard system is something that's going to be very important. Now, some American companies and some Chinese companies have not played fair, and a couple of European companies have not played particularly fair with standards. I would say that is a thing that can keep a country like Brazil down, because then you're going to be required to build it all yourself. So look for ways the government can play a role in ensuring that standards are fairly licensed. Not for free, not open, because then you lose the competitive fire, the monetary reward, but that they should be available to what we would term as any willing licensee. And I think a fair licensing practice will be important for building that healthy ecosystem. So I think you should not undersell Brazil, and I think that you should see that Brazil has incredible power, but I don't think you want to spend a lot of time reinventing entire ecosystems to go from there.
Yeah, I think that's fantastic. That's what I wanted to illustrate with my analogy with a whale, identifying whale system kind of system, because it is something that is completely possible to be done inside of Brazil, but we actually need different parts that maybe not necessarily developed by a Brazilian company, and it is something that is beneficial not only for Brazilian society but worldwide. So if you think about how to define a market in terms of AI, you have to look at, not necessarily the technology itself, but how you apply it in a different circumstance. So this is why it is very contextual, the way you have to look at this element of the market itself, about the solution more than and one particular element of the whole ecosystem, because maybe that particular element is the cornerstone for everything else that you have to build. And the ecosystem, if you do not have it as a very significant part of it, the whole ecosystem might crumble. But that's the thing about looking at very fantastic and potentially opportunities in terms of using new technologies. You mentioned about, like having the wheel, and then you develop a different type of car or a different type of, anyway, that can help you move things around or people around. But there's all other things that are relevant to the ecosystem itself. For instance, you have to have roads. If you do not have roads, but more than anything, modern infrastructure itself, maybe where you park. So this is part of infrastructure, but it's something that it is not necessarily public infrastructure. So that's different elements of the ecosystem that are relevant. And so when you define the market, look at the contextual relationship of the solution, and not necessarily the different parts that facilitate that solution to be achieved. So that's the element here that I find that it's crucial for us to see where you find the market itself, and whether you're going to look at it as a matter of competition or not.
Thank you, Christian. Professors Paulo and Juliana, do you have comments?
A short comment here, more on this institutional context that may be relevant for the promotion of startup companies. And historically, one of the largest problems that we have in business in Brazil is exactly those institutions. So the cost of doing business in Brazil is historically a problem. But I would say, I submit that that's not really the case with a competition policy and some types of regulations in Brazil in that particular moment now. So take the case of, we have several interesting examples of in the financial market of startups that they are really successful, like Nubank. I think it's the largest digital bank in the world. PicPay, C6, other digital banks that flourished in Brazil, iFood. So we do have the capability of building those companies, and they are flourishing. And partially they are flourishing because of environment that allowed them to flourish. So the actions by the central bank and actions by CADE were very important to provide leeway for those companies to expand in a moment that the incumbent banks were trying several strategies to limit the growth of those companies. So I don't think that we have a problem here, for at least in some of the sectors. And I think also, final comment, Morgan raised this very interesting problem, complex problem, which is, should we allow acquisitions, or should we be more restrictive to acquisitions by big tech companies buying startup companies, for instance? And he's right to say that there is this incentive to create a company, which is to be bought in the future by the big tech company. And on the other hand, we may have acquisitions that may play a restriction of market preemption, or so you restrict the growth of particular startup. So it's something that I would be very careful. In the last years, I think my opinion is changing a little bit towards more restrictions in mergers and acquisitions than before.
Okay, I think Professor Paulo mentioned two things that I think we must consider here, and especially related to the open banking movement that we had in Brazil and open finance. I think we have recently different and good examples to give, like the PIX is a huge revolution here in Brazil, and it's something when we share outside Brazil, everybody's curious about, right? And you can see some different banks that they are now very concerned about it, right? Because they need to develop new products, because nobody now is using old products that they used to, in everyday business, or as something that everybody used before this. But when we think about other markets, I think, and now we talk a lot about the AI revolution. I think I have a concern about the fact that many people is discussing this, but they don't know nothing about it. And I am following some discussions here in Brasilia that I am now. And I think that first, if we would like to develop something new or useful, thinking about protecting the market, and we first need to understand the harm that we are talking about. I think the theories, they are very good, but we need to discuss a little bit more about harm. And I think this is a point that is missing here in the whole discussion. And maybe this kind of debate that we are having now today, it's something that we should share, or we could make a movement to share to those that are concerned about some problems that they don't know exactly how to deal with, and to avoid, new tools that must be can be good, but in fact they can also create barriers to this innovation movement that we saw nowadays.
Just a quick answer to Professor Paulo about sometimes it's referred to as catch and kill, where a competitor sees a company that is coming on the horizon, buy it off, and kill it off. The problem that creates is, and this goes to something Juliana said earlier about how do you enforce it. The United States attempted to do something about this, and it backfired in a very bad way. Fortunately, they pulled back the regulation, so it never went into effect. But the U.S. said that they would essentially review every merger that was over $119 million U.S. So they set a cap. And you'd say, oh, well, that's good because the small companies won't have to worry about it. Wrong. The exact opposite happened. That became the new high bar, and now it drove down the price for all the legitimate companies. Because now everyone knew what the top number would be. It would be 118 million. So now, before your company was maybe worth 50, and now they were saying, well, we'll give you 30 because we have to buy other companies to get to that number, and we'll know that we will never have a company that will be bigger than that. Fortunately, they revisited it and they pulled it back because the venture capitalists just changed their mind because, he was talking about whales earlier. Venture capitalists are sharks. They live to swim and they live to eat, and they want to eat the next biggest meal. And so when the venture capitalist is told, I can't invest in this company, then they find a new place to eat. One of my small members said, the first question they are asked when they go to a venture capitalist is, who will buy you? That's the first question that a VC asks, because they're sharks. They want to know where their meal is going to come from. And you can say, I hope to become IPO, I hope to become Google. And they'll say, yes, yes. But who would buy you if you don't make it? Where will I feast? And so you have to be very careful as that law goes because it ends up pulling back money that small businesses need. So both Paula and Julia were right. It's important, but not easy. And it's something to be reviewing and paying close attention to. So I appreciate your comments on that. It's going to be a continued work.
And just for a final comment, because I find it is important, it is relevant. One big difference of AI from other different digital movements in general in the digital market is the fact that AI, the next meal is not necessarily from a big tech. Sometimes it's the other way around. It may be a small tech, or it may not be a tech company at all because they want to become techs to a certain extent. So industries that today maybe not necessarily techs might benefit from joining and buying other tech or buying a tech company, a AI company, or going in that direction. And actually, it is much better for the environment because in the future, because it is a technology, general purpose technology, it means that it will be a part of any new product or any new service that you have. At least one specific part or many parts will have AI in it. So maybe the next meal is going to be in a different company, in different structure.
I would say, I think the term tech is kind of silly because Petrobras, right? Huge part of Brazilian money out of it. It's going to use AI to make determinations about where to drill. They have patents on many of their drilling capabilities. Brazil is a heavy exporter of coffee, right? Built this city was coffee. Well, guess what? I have companies now that build little tiny devices that monitor fields and pull that data in, and using AI develop a pattern to improve the output of your agriculture. So is a coffee farm tech? Yes.
So on this note about AR markets or markets that can be related to AI, looking at market power in digital markets, we see a lot of criticism, often in the sense that authorities may have failed in identifying market power or in impairing concentration of that market. Do you think that we have learned any lessons that authorities are now applying concepts or assessing markets differently? And how do you think these lessons can be used or should be avoided, maybe, regarding AI markets? So I guess the question is very general. You can discuss, please, the relations between new AI-related markets and digital ecosystems that may influence or may have lessons to give to AI markets or not, that may be something entirely different.
In 2008, the GDP of Europe and the GDP of the United States were roughly equal. That is no longer true. Almost all of the growth in the United States has been through technology, and Europe has been stagnant. And I think it's very important to pay attention to the antitrust aspects of this. There was a survey done by the European Union of companies like my members, small companies. They surveyed 3,500 companies, and they asked him what were the opinions of small tech businesses in Europe about these regulations. So GDPR, only 15% of the small businesses surveyed has a positive view of GDPR. EU Artificial Intelligence Act, 20% positive. Visa policy was 23. Digital Markets Act, which is the biggest antitrust, 22%. 38% said it was neutral, but only 22% saw it as positive. Digital Services Act, that was 21%, 39% saying neutral. Antitrust reviews, only 19% of European small businesses thought that the antitrust reviews that Europe had done had been effective. 41% said neutral, so that's important. But you're looking for government to do something positive. And Europe is looking at the time from 2008 until today, and the small businesses, and this was a survey not done by some lobbying group, this was done by the European Commission, and the numbers are rough, and I'm happy to distribute it. But most European businesses do not see the last few years as being a positive. I would say, my own opinion, GDPR was hard but necessary, and the rest of those were, I don't know that they worked.
Thank you. I wasn't planning that much to talk about it. This is fantastic. Those interesting numbers. They tell you something about it. Is that if you're going to look at how to regulate markets and how to regulate the digital market, you have to look at all the consequences of it. And the consequences of this market are fantastic in all the ways, in ways that we cannot imagine. So changing specific points in a otherwise might necessary law as GDPR might make a huge consequence in terms of how you can, for instance, use and access data that wouldn't be necessary for other companies to become tech, as you mentioned, or to have tech inbuilt in it. So I thought it was fantastic, your idea that, basically tech, what it is, what it means, because to be honest, in the future, if you look at it, everything will have a tech component into it, or at least part of it is going to be AI component. And this makes a huge difference. In terms of Brazil, if you look at this, you can look at this from a very narrow lens of what it is the market today, and you look at, maybe a few companies are going to be very dominant in terms of AI. But if you do it well, in just a few years, the GDP of Brazil and the amount of other companies in AI can explode. It is a country that has a lot of inefficiencies that can be bridged using AI. So if we allow for a space for a huge market to continue to grow, we will have fantastic changes in Brazil coming on. And maybe what you're saying about different Brazil position in terms of developing or being developed or using its resource better, I think this is the moment that Brazil has in many ways to leapfrog. And changes in the way you look at competition are one of them. I would go tons and tons of times more on how you regulate AI nowadays, because, well, today is the day that it is being discussed in the Senate. But in terms of competition, it also is look at what you are regulating. If you're looking at AI as the element that you're regulating, maybe that's not the case. Maybe you should look at the solution that uses AI and that market as the order. Yeah, behavior could be one of those as well, yeah. But the thing is, it is contextual. You cannot do it ex-ante completely, because you have to understand how this solution itself is going to be used.
Thank you. Professors Juliana and Paulo, do you have any comments?
Juliana?
Yes, in fact, I would like to add a different perspective related to lessons, right? Like thinking about the judicial review. I think the main lesson is that we must take care about proceedings, especially the agencies and regulators, because the courts, they don't know about the markets we are discussing today. They don't know about relevant market, but they know a lot about process and administrative proceedings. And even with the best economic analysis, if there is something wrong related to the process, the whole case will be contaminated. So this is something much further than what we are discussing now, but it is something that in the practice we saw a lot. We saw the courts looking for problems related to the whole process. So that's why I am a little bit concerned when we create more steps inside the authority, because we really need to develop this capacity building inside the authority to make it work in the way we are thinking it's the best way to preserve the innovation and also preserve this, campus for developing new technologies.
Well, my comment is on the things that are most challenging in enforcing competition law in digital markets. And I don't think it's actually the problem of assessing market power, which is the subject of our session. I think it's more a problem that you know for a while, which is defining the relevant market. And so I conducted a poll once at IBRAC with hundreds and hundreds of experts in the field, all the experts in the field in Brazil. And they were asked to approve or reject the mergers between Facebook and Instagram and Facebook and WhatsApp. And the majority thought that it was problematic, the acquisition by Instagram by Facebook. And if you go to the decision, they were considering different relevant markets. But of course, you know that these ecosystems, they develop new functionalities in adjacent markets, and they are more like the same a few years later. So this is one thing that was told in this session, the unpredictability of the innovation. So makes very difficult to define the relevant market. And also Christian said that about AI. So I think one of the things that I take from Christian's talk is how difficult it is to define relevant markets in AI, AI solutions, what type of solutions, but normally not a general use, purpose use technology. And so this is something that we really have to put our effort, I think, to have a proper assessment, or even avoid the assessment and try to circumvent the assessment.
I think that's an important element for this. It is difficult, and particularly when you look at a priori. So if you look at before you understand what the solution does, and if you look at the technology, I think it is particularly difficult. And that's one difference that I would see, and correct you, the experts in competition law much more than I am, is that when you look at all the relevant instances that we are discussing digital markets, we were looking at digital platforms and digital, particularly more than anything, we are looking at e-commerces or we are looking at social networks that were in themselves siloed elements. And in terms of AI, all the different stacks of AI, they're up for grabs. There is competition in the different stacks. There are different competitions in the solutions that using AI will achieve. So in my point of view, the difference here is that Instagram is a closed platform. Google is somewhat a closed platform. When you're talking about AI, you do not see the same thing. You look at the solution that was made using different elements, different systems of AI, using the technology, and then you look at whether it is a market that's relevant, that might be impacted. So if you look at harms, the harms will come from the application, the solution that was developed more than anything. So that's a tiny little different that I wanted to highlight.
But I think it raises an important competition point because, for example, do we say that a market is the foundational model? Do we have that? Is that a market? Well, that's really difficult because the foundational model as the market that then has to be gone under antitrust review, the way that that's utilized is so wildly different, right? If I use a foundational model and then I add my own data, but I keep it in a silo and so it's never shared, I am changing how that foundational model looks at products. In the end, my algorithm will be different than yours if you are using a separate model. So then if we don't do it that way, you have a question that you said about, well, how different companies are open. Do we say the market is all? But here's where there is some very interesting, and we'll all get to watch this, interesting fight about market and consumer choice. Apple is taking the perspective that privacy is most important, and also because they're a hardware company, they want to do hardware on the device. And their argument, and it is a sound one, is that if the data never leaves your device, it can never be stolen. That's the argument. But that raises questions of, well, how does people see how the algorithm is built if there's no transparency in how it's done? On the other side, if you have a purely open model, then you have opportunities for misuse and bias and information. One of the things that happened very early on was using the way that AI engines had been trained on huge public databases to essentially crack people's passwords. It's very effective. So you have a consumer battle, a choice now with the way that consumers will see this. Is it better to be focused on privacy first? Is it better to be cheaper and be done open with more risk? How will the consumer respond? So for Juliana and for everyone else, and for those at CADE, how do you analyze those markets? Because they are taking different bets and different risks on what consumers will respond to. So I don't even know if you can define it as AI as a market, because wildly different approaches by different companies. Amazon has a different approach. Microsoft has a different approach, not to mention OpenAI, and then some of the models that we're seeing out of China. So there's a huge battle now for ideas and for what consumers will like.
Thank you very much. We did start a few minutes late, so if everyone is okay with it, I think we can extend a little bit to see if we have any questions from the audience. Before that, Christian would like to... 5 minutes. Oh, okay. So do we have any questions from the audience? I think in 5 minutes we can address them. If not, I think it's been a great panel. I would like to thank very much each of our speakers. It's been very, very insightful. Thank you all very much.
Thank you to our moderator. Thank you.
afternoon to everyone. Let us start this panel 3, which is about market failures or ecosystem failures, how to encourage competition. We have here to compose this panel Diana Moss from the Progressive Policy Institute, who is joining online, right?
Yes.
Fernando Soares from Conexis, Mônica Fujimoto from Horta Bachur Advogados, who is here with us, and Nicolo Zingales from Fundação Getúlio Vargas, Rio de Janeiro, who is also joining online. I will drive some comments on the subject matter of this panel, and then leave the floor for our guests for their presentations around this subject, which I think it's very important to organize the thought about all the initiatives in the regulation or ex-ante regulation of digital markets. Within the effort of regulation of ex-ante regulation, by imposing obligations that should be complied with independently of showing efficiencies of the conducts which are forbidden, provide an important insight about the whole project. If by the end of the day, showing of efficiencies will not be considered in the evaluation of these conducts, this means that probably we are not within this effort. The point of the whole regulation is not to correct market failures, because by market failures, of course, we will not understand by this term excess of concentration, but we are concerned with market inefficiencies. Inefficiencies by the structure and the dynamics of the markets to offer consumers options, alternatives, in an environment of innovation. So, if it is not about preserving market efficiencies or correcting market failures, what is this all about? And one of the replies to bring into another conception and propose that the ex-ante regulation is in service of a concern of an ecosystem failure. And by ecosystem failure has to do not exactly with market efficiency, but in a just or fair distribution of the values generated within a group of enterprises that interacts together by offering services. And this is it's a key distinction in the whole discussion in attempts to justify ex-ante regulation. If we take, for example, the case of the platforms in relation to websites of journalism companies, we have actually a social problem about the sustainability of journalism, considering that in terms of efficiency, platforms enable the access of journalism enterprises to new consumers, to new opportunities of reading, so there is no problem of efficiency here. Instead, the fact is that by the new form of information consumption in social media networks and etc., The big problem is that platforms attract most of the income on advertising. So it's not only that there is no fair distribution of the value generated by the ecosystems among individual companies that compose this ecosystem. So it's not a problem about individual rights only. It's fair for an individual company to share the gains of the whole activity that is being captured by the orchestrator, by the big platform. It's not only about that, it's also about the very sustainability of ecosystems in fields of service that has also public interest. So it's not only a private matter, and this is a confusion that may be brought about, or this is a private interest that does not concern antitrust. Antitrust is only concerned about public policies and public interests, or collective interests. When we talk about not only a fair distribution in terms of individual companies have access to a fair share of this value that is generating is this chain of production or of services, we are also talking about a public concern of sustainability of some activities and some services like journalism, which are important, for instance, for another or other values that are key to democratic societies. So within this very difficult setting that we have the pleasure and the honor to have important specialists that I'm eager to hear in this very, very, very difficult and new setting of the problems which belong, some would say that does not belong to competition law. It does belong to competition law. It does belong to public interests. And it has a different tune. It's not only about efficiency, it's about fairness. And so, first of all, I would like to invite Diana Moss from the Progressive Policy Institute. Please, Diana Moss, welcome. We are very glad to have you here with us in this debate. And please, the floor is yours.
Thank you very much. And it's an honor and a pleasure to be invited to speak on this program on this very important topic of digital market competition and regulation. I am coming to you from Colorado in the United States. PPI, the Progressive Policy Institute, is a Washington, D.C. based think tank, and we have quite a number of experts working on digital policy, both from the international trade side, technology, and competition. I recently wrote a report, you can find it on our website, on what I consider to be the lack of a competition policy worldwide in the digital sector. The digital sector poses a number of challenges and problems for policymakers, competition policymakers, technology policymakers, political policymakers. And I make a very evidence-based case for why we really don't have a coherent competition policy in the digital sector, and why that is the case, and why that is something that we need to address in a coherent way. So let me just start off by saying, first of all, the digital sector is enormous. It is enormous. The global market for digital transformation is expected to grow annually at about 24% per year through the year 2030. The global market for digital transformation is worth about $1 trillion US in 2023, 2024. So the digital transformation, as it impacts commerce, as it impacts society, as it impacts culture, technology, economics, the political economy of countries worldwide, is not going away. In fact, it's only accelerating, which makes us focus our lenses and our policy tools more carefully on the digital sector. The digital sector is very highly productive and dynamic. There is a lot of new entry of firms. There is lots of labor mobility in the digital sector. It is not a stagnant, declining sector with low levels of economic growth. It is fast moving. It is changing rapidly and will continue to do so. So that also highlights how important it is for us to think very carefully about digital policy. So I would say that one of the biggest challenges that we face as policymakers and competition experts is the very unique features of the digital sector. And I have focused in on my report on what I call the digital business ecosystems, which you all know really consist of three major parts: a platform of some sort to bring users and providers together, a cloud technology to harness the value proposition of bringing users into the ecosystem and keeping them in the ecosystem, preventing them from switching to competing ecosystems. And finally, a constellation of applications in the ecosystem, whether it is fintech or health tech or travel or any other applications. So we're looking at these three-part ecosystems as a platform, cloud technology, and applications. They have a number of very unique economic features. One, obviously, is that there are numerous market failures. In the ecosystems, there are information asymmetries. The platform owners know much more about you and your preferences than you know about them and what they're doing with your data. So that's a classic market failure, information asymmetry. We see network effects, meaning the more users that join the system, the more valuable it becomes. We see data externalities. Just a small amount of data can be extrapolated to much larger populations and groups. We see the other economic phenomenon like economies of scale and scope in cloud technology. So these are very, very unique economic organisms and very unique business models. They also grow primarily through acquisition. The digitals, in a study that I did last year, looked at a sample of large digitals and super digitals and a control group of non-digital firms. Digitals are by far larger and more valuable than non-digital traditional manufacturing type firms. They are astronomically larger and more valuable, and they have grown largely not through organic growth, internal research and development and innovation. They have innovated by buying smaller companies around them to integrate into their ecosystems. So as economists and lawyers and policy experts, we need to pay attention to how these businesses grow. And in fact, the digitals, the original first generation of digitals, the big five, here in the United States, Amazon, Google, Microsoft, Meta, Apple, they peaked in their acquisition, their external growth in about 2014. So about 10 years ago, they actually reached the peak of their acquisitions. And they have been on the decline since then. It's very, very interesting. We are now seeing the second generation of digitals emerge, digitals in more specific focused applications like financial technology, healthcare technology, other areas. Those digitals are growing very, very rapidly as a second generation and a third generation of digitals. We have also seen, and I show this in my study, that the digitals have created a special very intensive area of acquisitions, and that is in cloud technology and artificial intelligence. And that cycle peaked around 2018 and is now on the decline. So these systems have been fully built out over the last 2-3 decades. And that's a very important thing to remember as we move forward. So I want to just finish up my remarks by saying these very unique business models have posed a challenge for competition policymakers, antitrust enforcers in the United States, in Europe, and other countries like Brazil and Australia and Canada. They have posed dramatic challenges, and we still do not have a coherent policy approach to promoting competition, protecting consumers, protecting smaller innovators, ensuring market entry. The US and Europe could not be further apart. The US has rejected, at least informally, any sort of regulation. Europe, on the other hand, has the Digital Markets Act, which sets up this system of ex-ante compliance regulation. Whereas in the US, we are seeing antitrust really have a very difficult time of it. We have virtually no merger enforcement in our digital sector. We see that in our merger statistics. There have been very few, if any, digital mergers challenged by the US Department of Justice and Federal Trade Commission over the last 3 decades. Just recently, under the Biden administration, which is now turning over to a Trump administration, we saw some challenges to digital mergers, but they were not successful challenges. The agencies lost their cases. So we have this very difficult situation in the US where we have had virtually no merger enforcement, but then in a very, about 5 or 6 major monopolization cases against the digitals. And those take a lot of time to work through the system and the courts. And that is not a particularly responsive or efficient tool to manage or control the market power of these very large companies. And of course, the backdrop for managing and controlling competition in the digital sector takes place against this very dynamic backdrop of growth, of technological change, of rapid change, to almost to the point where in some cases we are looking at some of these large digital platforms being displaced by new technology. For example, Google search at some point may well be displaced by the use of AI, artificial intelligence. And so we have a dynamic competition element as well to think about as we create policy. So moving forward, we're still looking at efforts in Europe and in the US and other countries to promote competition on platforms, intra-platform competition, but we're also looking at efforts to continue to promote inter-platform competition, which would promote the development and entry of new platforms so that consumers will have choice about where they seek to get their products and services. So in sum, I think we're dealing with a very difficult, challenging policy problem, and I'm very heartened to see people in Brazil and other countries looking at the European experience, looking at the US experience. Neither of those experiences, I think, pose particularly good solutions. So we may have to start changing the way we think about how we're going to craft public policy around the digital sector. Thank you.
Thank you very much, Diana. I believe you're completely right. And there is an interplay, actually. It's not only that the policy is incoherent, as you said, but there is also a problem of effectiveness of enforcement. The preventive enforcement by merger control is quite important in the dynamics of the market, since the ex post reaction by enforcing conducts may be time inefficient. So, and of course, the lack of effectiveness has to do also with lack of coherence in the measures, in the methodology, and in the core lies this distinction between what is the whole point of competition policy within digital markets. Are we pursuing market efficiency, or are we pursuing fairness in ecosystem? So, and these two different points leads to different remedies, measures, or methods of analysis. And within incoherence is very difficult really to achieve an effective enforcement. Thank you very much for your insights. And now I call Fernando Soares from Conexis. Fernando, thank you very much for joining this debate. The floor is yours.
Thank you. So sorry, but I need to speak in Portuguese. I think you better for me. So I speak in Portuguese. Boa tarde a todos e todas. Muito obrigado pelo convite para participar desse segundo simpósio, né, de mercados digitais. Eu pertenço à Conexis Brasil Digital. A Conexis Brasil Digital, só para localizar os senhores e as senhoras, ela é uma associação representativa de empresas de telecomunicação aqui do Brasil. Então, primeiro ponto que eu acho que nós temos que discutir, estou observando aqui meu tempo para não esgotar meus 10 minutos antes que eu termine aqui minhas anotações, market failures or system failures, how to encourage competition. O que nós estamos falando? Nós estamos falando do ecossistema digital, estamos falando da definição de um mercado e estamos falando de falhas de mercado e especificamente falhas de competição, tentando fazer a análise dos elementos aqui associados ao painel. Então, a primeira coisa que a gente tem que fazer, definindo aqui o nosso painel, falhas de mercado ou falhas do ecossistema digital. A primeira coisa que a gente tem que pensar quando eu tenho um problema de falhas de mercado, inclusive uma falha de competição, é em relação ao mercado que nós estamos tratando. Então, a gente tem que definir aqui o mercado relevante de produto. Então, já temos aqui diante, e eu concordo com a professora Daiane, a gente tem muitas dificuldades, muitas inovações. Então, o primeiro elemento é a definição desse ecossistema digital, definição desse mercado digital e definição desses novos players que estão nesse mercado digital. E mais que isso, é um mercado em constante transformação, numa dinâmica muito acelerada de transformação. E aí, uma coisa que a questão que a professora Diana falou, nossos policymakers estão preparados para enfrentar isso? Essa velocidade toda com que esse mercado se transforma? Essa é a primeira pergunta que a gente tem que se fazer aqui. Dando um exemplo, serviços de voz. Serviços de voz em telecomunicações praticamente desapareceram. Agora eu tenho serviços de voz que são prestados a partir de quê? Aplicativos derivados de grandes provedores de conteúdo. Você tem uma brutal transformação, uma descomunal transformação. Desse exemplo, eu pego já, então, o exemplo da própria internet. A internet em si passou por imensas transformações. Me permitam aqui fazer uma digressão. Lá no início dos anos 2000, cunhou a expressão, que foi altamente defendida no mundo, da neutralidade de internet. Da neutralidade da rede, que seria a neutralidade da internet. Qual era a preocupação no início dos anos 2000, particularmente quando o Wolff fez isso em 2003? É que os provedores de acesso à internet, à época com grande poder de mercado, pudessem, de alguma forma, limitar o fluxo de conteúdo da internet. No entanto, a internet, naquele momento, ela era completamente atomizada, composta de centenas de milhares de provedores de conteúdo que, obviamente, não tinham capacidade de influenciar o mercado. Por isso, a neutralidade de rede daquele momento. Pois bem, a dinâmica de mercado mudou, as coisas modificaram, a tecnologia modificou. Por exemplo, o que eu acabei de dizer, eu tinha serviço de telecomunicações por voz, e agora eu tenho voz a partir de aplicativos de conteúdo. E aí, o que acontece? Eu tenho que a internet codifica completamente e os players são completamente alterados. Aquela internet que era uma vastidão de milhares de entrantes, de provedores de conteúdo, hoje você não tem esses, não é caracterizada por um segmento, um ecossistema tão atomizado por inúmeros e pequenos provedores de conteúdo. Muito pelo contrário. No Brasil mesmo, eu tenho o quê? 5 ou 6 empresas, grandes empresas provedoras de conteúdo, elas já dominam 50% ou até mais de todo tráfego de conteúdo na internet no Brasil. Novamente, 5 ou 6 empresas dominam algo superior a 50% do tráfego da internet no Brasil. Então, o que eu quero dizer? A primeira coisa é que aquela preocupação que tínhamos da neutralidade de rede lá no início dos anos 2000, 2003, está completamente ultrapassada, e a própria discussão da neutralidade de rede, como nos anos 2000, merece que todos nós venhamos nos debruçar sobre ela e discutir e pensar sobre ela. Porque ela, da forma como posta, ela, sinceramente, não é mais relevante. Mas disso que eu estou falando, a outra parte aqui do painel. Falhas de mercado, e sim, tem a questão de fairness, né, da justeza, digamos assim, versus a eficiência, mas eu acho que nos é relevante trazer, mais uma vez, a questão da eficiência e da competição nos mercados digitais. Então, a primeira coisa, a preocupação com os provedores de acesso e um possível controle por parte deles, isso não está mais presente. Na verdade, eu tenho uma situação inversa, no qual os provedores de conteúdo, ao dominar o tráfego na internet, esses têm capacidade de fazer um verdadeiro fechamento de mercado. Fazer um fechamento de mercado para os provedores de infraestrutura, ou seja, as empresas de telecomunicações, e que a gente pode aí discutir, inclusive, utilizar a questão se é justo ou não, inclusive a discussão do fair share, e mesmo o fechamento de mercado para empresas nascentes da internet. Então, eu traria esses dois elementos profundamente associados a falhas de mercado, ou pelo menos discutíveis do ponto de vista da falha de mercado, que eu acho que a gente merece uma interpretação nossa, uma discussão nossa, exatamente em relação a isso. Hoje, esses provedores de conteúdo, tem alguma forma de fazer algum market foreclosure em relação aos provedores de acesso? Essa é uma primeira pergunta que tanto a academia quanto os nossos policy makers deveriam se debruçar. E a outra coisa também é que essas empresas que hoje dominam o conteúdo, o mercado digital, são tão grandes que elas estão impedindo efetivamente o nascimento de novas empresas nesse segmento, claramente por um processo agressivo de aquisição de empresas nascentes, de startups nascentes nesse ecossistema digital. Essa é outra pergunta que a gente tem que fazer. E isso, por um ato ou por outro, está gerando um impedimento a uma prática, a um mercado mais eficiente, mais concorrencial. Então, essa é a pergunta que eu faço. Uma pergunta quase que retórica, que é uma afirmação. Esse novo mercado digital, sim, está conduzindo a algumas práticas anticompetitivas que nós temos que, atuando tanto por meio da defesa da concorrência como por meio de advocacy, tentar prover uma atitude diferente para ter um mercado mais competitivo, mais concorrencial e mais eficiente. E aí eu me trago ainda, se me permite, quase que para encerrar aqui, eu acho que meus 10 minutos já estão encerrando, voltando aqui para falhas de mercado. Já afirmei que falhas de competição, a meu ver, estão presentes no ecossistema digital atual. A outra pergunta, e a pergunta não é só para as autoridades brasileiras, mas as nossas autoridades antitrusts estão preparadas para esse novo mercado digital, por esse novo ecossistema digital, ou precisamos analisar novas ferramentas para explorar tais condições? Segundo, geralmente, quando falamos de defesa da concorrência, a gente defende a aplicação da regra da razão, né? Geralmente não queremos ex-ante definir práticas anticompetitivas, a gente não quer usar o per si. Mas, dada as características desse mercado digital e desse ecossistema e do poderio apresentado por determinadas empresas desse sistema, além da prática antitrust, será que precisaríamos ter uma regulação ex-ante? Não estou colocando agora como uma resposta, mas como uma possibilidade de que talvez a prática antitrust tradicional, com a regra da razão, não seja suficiente nos mercados digitais. A outra questão aqui que eu coloco, que aqui não é nenhuma dúvida, mas que a entidade antitrust, ou a agência, a autoridade antitrust, agir para e passo com as autoridades regulatórias envolvidas na matéria é uma condição sine qua non. Elas têm que trabalhar extremamente de maneira próxima. Por exemplo, neste caso, eu não acho que seja matéria meramente do CADE. Eu acho que o CADE teria, dentre outras, que ter um trabalho muito próximo da Anatel nesta questão dos mercados digitais. E por fim, há outras falhas de mercado presentes, além das falhas de competição neste nosso novo ecossistema digital? Sim. Não cabe aqui a discussão, porque aí extrapolaríamos o tempo, isso pode ir para outras perguntas, mas claramente, além das falhas de competição, eu tenho problemas de externalidade positiva, eu tenho problemas de mercados incompletos, eu tenho problema de free riding, eu tenho um problema de assimetria de informação, enfim, temos efetivamente um novo mercado, todo esse mercado digital, com toda a sua dinâmica, mas ele trouxe consigo um sério de problemas do ponto de vista da eficiência econômica, que estamos ainda, a meu ver, no início para se debruçar sobre essas matérias e enfrentar. E aí, concordo com a professora Diana. Só para concluir, defendendo os consumidores, defendendo empresas entrantes, enfim, fazendo um mercado não só mais eficiente, como mais justo para todos. Muito obrigado. Desculpa aí se eu extrapolei um pouquinho o tempo.
Very much, Fernando. Very instigating questions. I'm sure the audience feel provoked by them, and I hope we'll have some time after the panel to have some debate on them. It's interesting also that you call attention to the fact that the same question are regarding orchestrators and complementers in online service. The same question about, are we looking for market efficiency, or are we looking for ecosystem fairness? The same question, or both, but the same question, yeah, it's interesting that the same question, as you have remarked, is present in the relation between online services and the infrastructure for service connection. So the same actually question is present and can be explored to try to hit or to achieve some coherence in the policy, as Diana Moss claims that we should. Thank you very much, Fernando. I will now leave the floor for Mônica Fujimoto from Horta Bashur Advogados.
Thank you, Professor Juliano. It's a pleasure to be here to discuss this important theme with all of you. And Fernando, I understand you that you don't want to speak in English. I'm also smarter and funnier in Portuguese, but I will do my best for you to understand me and to bring some maybe questions, as Fernando did, but some considerations over this subject, but from a legal perspective. When I saw the title of this panel, Market Failures and Ecosystem Failures, I was thinking, should I talk about the economic perspective as we are dealing with this antitrust and competition discussion? But I really think that my colleagues are better to do this, like Diana Moss did a excellent report on this. I think Nicolo is also excellent, and he's going to talk about this other perspective. And I think Fernando talk is very much what I want to discuss here, because it's about the policy framework. And even though Fernando talked about a lot of net neutrality and this telecommunications perspective, and I very much appreciate Conexis' work, Fernando. I used to work with Natasha and Maria Elisa from Conexis, and we discussed a lot of data protection, elaborating a good practice guidelines in Conexis. But I think that when we are talking about competition and to how to encourage competition, we're going beyond only antitrust discussions. We are going beyond only these efficiency discussions, as Professor Juliano said in his opening speech, because these market failures, when we talk about market specifically, sometimes we tend to think that these market repercussions are only strictly concerns to market players. And here we have a broader problem. I think Diana talked about this on her speech, and we don't have only market failures to deal with on digital ecosystems. We have a lot of rights that are not being protected. We have a lot of not only human rights and problems with democracies and problems with work organization, but we have a lack of rights that are being granted to other competitors on this B2B relation. So I really wanted to start to talk about this theme and trying to explain why I think why competition is not an end in itself, because we must grant rights. We must grant rights to other competitors, we must grant rights to the users of the services, and when we talk about competition and when we talk about digital ecosystems, we must go through these points. And I think Professor Juliano, I noted what he said about market failures and being related to the discussion about efficiencies. And when we go to ecosystem failures, we are talking about fairness. We are talking about contestability. And it's not because competition and it's not considered when we talk about contestability, but I think there is a broader sense of what we are protecting. And this is my starting point. I think that we should go beyond only this concept of market failures, only thinking about monopolies and information asymmetries, because here this is only the beginning of the problem. Because if we deal with this this exercise of only trying to define what are the relevant markets on digital ecosystems, I believe that we are going to get stuck on this discussion that maybe is broader than that, especially when it comes to Brazil. And in this moment, we have a broader discussion about how to encourage competition that also goes beyond antitrust. We have this artificial intelligence bill that's being discussed on the Congress that I don't think that only relates to this specific part of artificial intelligence that it grants transparency and their rightful use of technology. But we have an important impact on competition also. Because for me, when we are dealing with power dynamics on digital markets, these power dynamics that are different from the traditional markets go through a capacity of processing information, of processing data with precision and in an efficient way. So if we are going to discuss competitive advantages on digital markets and not on companies that use technology, we must consider when artificial intelligence is a competitive difference, when is a competitive adventure, when is a competitive advantage per se. So talking about the difference again from market failures and ecosystem failures, the first thing that we should consider and what's the part of technology on the competition dynamic. And here we must consider the importance of data also. Because, again, when we are dealing with this regulatory approach and this moment that the digital economies try to address the concentration of power of 5 or 6 big companies, right, Fernando, that has 50% of the traffic, and we're dealing with a decision on how the state state is going to address this question. How are we going to protect rights from users, from companies, and at the same time promote innovation? That I think that is the main discussion when we are dealing with these regulatory matters on digital platforms. I think all the arguments against regulating digital platforms go through we are going to reduce innovation, goes through a concern that is very valid, that we are going to reduce innovation. But here we have to understand that the intervention of the state on the markets comes from a constitutional provision that gives us the possibility to control abuses of economic power. And nowadays, abuses of economic powers, when we are considering digital markets, goes through a very difficult market and a very difficult difficult process of investigation and of assessing whether an abuse happened or not. So just trying to answer this final question, this question that this panel proposed, how to encourage competition, I think we must talk about regulation. And we must talk about the main regulatory framework that is under discussion nowadays, that is the Digital Markets Act. And how this Digital Markets Act framework, this ex-ante framework, is possible to be discussed in Brazil. What we actually have of innovation on this regulatory framework. And to be honest, I don't think that everything that we are calling an innovation on this regulatory framework actually is an innovation when we think about traditional antitrust. We already have per se conducts. Cartels are per se conducts. We already have ex-ante regulation. We have a merger control that is ex-ante antitrust. We already have a regulatory asymmetry that the DMA introduces, focusing on digital platforms. We already have a certain, we already have the possibility of considering new concepts and values. When we read our antitrust legislation, for me, it's clear that CADE could have the competence to regulate digital platforms. But does CADE do we as a society have the legal trust, or do we have the confidence that this institution is not going to abuse of its regulatory power when we interpret the historic of CADE's work on digital platforms? Are we going to, do we have this confidence that CADE can monitor digital platforms if there's no case under investigation? I don't think that this answer is simple. I don't think that the answer of which conducts are we going to consider per se is simple when we don't have any conduct that was sanctioned by CADE. We have here like a state of this debate that is very that is only on the beginning, and I really think that when we are talking about how to encourage competition in Brazil, we must expand the debate. We must talk about developing AI systems. We must talk about encouraging the development of AI systems. We must encourage, especially regulation that promotes transparency on platforms' decisions. We already have a legislation that is LGPD that protects data from natural persons. We must have this discussion on how to grant rights on the business perspective, as Europe is also doing on Data Act. When we think about antitrust and all these problems that antitrust regulation and that ecosystem market failures brings to the table, I strongly believe that the path is to have a integrated view of the problem, and to encourage, and we need to encourage competition from the beginning. I don't think that we should prevent small companies from being bought from aggressive acquisitions from bigger companies. Maybe in Brazil, this will prevent them from developing because we have a venture capital market that depends, for example, on these acquisitions. So to begin with this discussion, for me, what we must do is to look for the DMA and look for Brazil and actually understand what are the differences and what are the points that it's actually an innovation and regulatory innovation, and what we can do here in Brazil to prevent these abuses of rights and to grant, I think, what Professor Juliano said, and I think it's right, how to grant contestability and to grant fairness on these markets, because I don't think it depends only on an antitrust perspective. We must start discussing competition policy applied to these markets, and I really think we already have a lot of tools to do that. It's not something that is a complete innovation. So thank you very much, Professor, and I look forward for the debate.
Thank you very much, Monica. Just a remark, thank you for your insights. Just a remark on how I see things now here. You're hearing your talk. Well, regarding digital markets, there are three spheres of power involved. There's the economic power, there's the political power, and the informational power. In three cases, we have freedoms to be defended. We have the sovereignty of the consumer before the economic power. We have the sovereignty of the citizen before political power. And we have the freedom, informational freedom and informational autonomy of the citizen before informational power. These three spheres of power, they feed each other. They are interrelated, but enforcement policies are usually looking only for each sphere and not does not consider their interaction. There is data protection with protecting informational freedom. There is antitrust law defending consumer sovereignty. And it's an important remark that you do when you say, well, I'm just reinterpreting what you said. If we are not only talking about market efficiency, and we are talking about ecosystem fairness, so maybe we should open our eyes to other rights that are involved and may be affected by this larger concept of fairness. And one clear instance of that is the concept of exploitative abuse in antitrust. This is the way the precedents and the academic, the literature is trying to interpret this different rights. For instance, how can we enforce data protection in terms of antitrust enforcement? Well, there is the concept of exploitative abuse. We have had an example of exploitative abuse of the right to data protection, but we can also think about it in terms of other digital rights. When exploitative abuse may converge those concerns about fairness and about competition and efficiency in a way that we may enforce antitrust to also protect these rights. Thank you very much for the insights. And I'd like then now to leave the floor for Nicolo Zingales from Fundação Getúlio Vargas, Rio de Janeiro. Thank you very much, Nicolo, for being with us here, online at least, and to bring your thoughts for our debate.
Thank you very much, Juliano. It's a pleasure to be here. Thank you for the invitation, and good to share the experts and friends So I think it's already a lot has been said. So I agree with, but I wanted to maybe offer some remarks on the main questions of the panel relating the differences between ecosystemic failures and market failures. To start, I mean, I think, I don't know if this was done in other panels, but we haven't defined here the concept of ecosystem. So briefly, you know, a competition law talks about ecosystem in a way that is slightly different from what nowadays is being said when it comes to, for example, the information ecosystem. You know, that's a broader concept about all the online actors that are participating in and facilitating online transactions. But in competition law, we start from basically the concept of system theory that recognizing the importance of strong complementarities between products and services that would allow to consumers to internalize these complementarities if they are brought together to the consumer. So in ecosystem, what you have is a firm that acts as an orchestrator that attracts third parties that offer these complementarities that the firm doesn't have, and aims to create value for the consumers. So it will establish the rules for these third parties to bring products and services that the consumer wants in a way that is aligned with the vision that the orchestrator of this ecosystem has. And so nowadays, you know, we can think about app stores, marketplaces, even social networks as orchestrators of a broader ecosystem of players. And much like in the context of ecosystems in biology, you have the problem that ecosystem can evolve in directions and in ways that are unanticipated. So that's why you need somebody, if you don't want things to evolve in ways that are detrimental to society, you want a benevolent orchestrator that ensures that value production continues and that negative externalities are diminished or minimized at least. So I think that in this context, the position of the orchestrator is key because it will need to assess what are the failures that are occurring, you know, what are the main problems in this environment, and it will need to establish appropriate remedies against those problems. And I see at least two challenges in this respect. One is that as we have traditionally applied antitrust law, we have looked at markets in isolation, and traditionally we have required that the benefits from a certain measure accrue to the same group of users, the same group of consumers that has suffered the harm from a particular conduct. So it's not very much recognized in antitrust, or at least in very few cases has been accepted, the possibility to distribute across groups the benefits and harms, let's say. So in the concept of ecosystem, this is a challenge because you have to look at the whole, and it might be that to make some policy that has an effect of addressing a failure in your system, you're harming a specific part of the ecosystem, but this might be legitimate if it leads overall to a broader value in the whole set of players that are engaged in this ecosystem. So this is a first challenge. The first one has to do with the complexity of these ecosystems and the fact that it's not always easy to understand, you know, the results of a particular measure. So it's not a clear linear relationship between inputs and outputs. And this is even more the case when we are talking about artificial intelligence and predicting the conduct of very heterogeneous groups of players that are interacting in the ecosystem. So I think for this, we have even more the need for a central point of gathering of information and trying to assess the pros and cons of certain interventions. And so, again, the orchestrator is key, and we don't want to substitute, for example, the orchestrator with a regulator, because the regulator is out and have access firsthand to this information. It will be very burdensome and bureaucratic to require that every new measure in the App Store, for example, is vouched by regulation before it can be undertaken. But of course, we cannot all at the same time give carte blanche to the orchestrator. So here, what is often complained as a concern in digital ecosystem is that from value creation, the conduct of the orchestrator can transition into value capture and appropriation, or what has been called by Cory Doctorow as inshitification of the platform, which means that the platform is not really serving anymore the interest of its users. In the first moment, it will start serving only its business users and forget about the final users, and then eventually it will also create prejudice or harm for other business users to favor its own business interests. So we need to have some control, to prevent this from happening. And that is a big challenge for regulators, because you also need to understand to what extent the measure is necessary to recoup, let's say, some investment in the infrastructure that the orchestrator has done, and to what extent this is instead just an extraction of the rent that is due to a favorable position that the platform is in, but not necessarily that was earned by way of innovating and building products and services. So here we have some good examples that can show this tension. There is the Apple the Apple case, which also, by the way, is a very current case in Brazil. There was recently a preliminary measure issued by CADE, which has to do with the fact that Apple was requiring transactions and products and services that are offered in the app stores, even through the apps of the app stores. All of them, they need to go through the Apple Pay system, which enables Apple to charge the 30% fee for these products or services, its transaction. And Apple was forced in other countries as well to allow other payment systems, because that way this would enable also third-party payment providers to compete with Apple. And this has led to a situation in the DMA. Apple is being investigated because after it accepted third-party payment mechanism, it still required a huge transaction fee to be passed from the other payment services to Apple. So it diminished only by 2 or 3% the transaction fee that it was previously charging itself, and then now it charges to this other payment service provider. So here, what we have to ask is that 30% all a recoupment of the investment that is done in the moderation of the App Store, and, any security measures that are being taken, or is it just because they are trying to make as much money as possible from every single transaction without really having earned a Schumpeterian rent, what we call. It's just a Ricardian rent. So this is one case that I think is very useful to think about when dividing between the two types of behavior. So the benevolent orchestrator and the orchestrator that might be shifting towards a more appropriatory type of conduct. And another case, which is an interesting one in point, is the case regarding booking and other services that impose MFN, and they impose this most favored nation treatment to prevent disintermediation. They don't want that the customers are using the platform to look for all the options available, and then when they have identified the cheapest, the best for them, they would finalize the transaction directly with the seller or on another platform. And here, again, it might be a very legitimate measure to prevent this failure, which is free riding. But who has the evidence to show that this is the case is the orchestrator. So what we can do is require the orchestrator to produce this evidence, and then, basically the regulator could question some of these measures depending on whether the evidence suggests that this is indeed legitimate. I don't know how much time I have left. I have a couple of more thoughts. Could you just give me a notion of the time? Okay, good. Thank you. So then another thing that I think is interesting in the analogy between market failures of ecosystem and traditional market failures is here the ecosystem orchestrator enjoys through effects and economies of scope some values that then it can distribute to the whole ecosystem. And I think there is a difference when it comes to the traditional approach to utility regulation, where they look at these network effects as basically a problem for new entrants that will not be able to acquire those network effects and economies of scope as well. And therefore, we need to intervene because of that. It's not always necessarily the case. In the case of ecosystem, the concentration of controlling one actor can also have some positive effects, including the better regulability of the ecosystem that need to be taken into account. And so we need to try to find a way to preserve the positive effects that come from centralization and control, but also address the problems of these conducts of appropriation or enshittification that I mentioned earlier. So here, interoperability might go in some way towards solving these problems, but of course there's also trade-off between the amount of interoperability that you impose, the costs also that are involved in enforcing interoperability, and the effects that you might have in the invest services. Because if you know that somebody is going to build, the orchestrator is building the infrastructure and then it's going to share it because it's going to be forced to share it, then you're not going to invest in the creation of alternatives. So I think that, maybe to some extent, the inclusion into competition policies of the creation of alternatives should also be part of the picture. So that it's not just about interoperability, but we need to have a vision for the creation of new orchestrator, new infrastructure that are maybe publicly owned and or publicly oriented. And this also might solve another problem, which is a problem of exploitation that was mentioned. Juliano, you brought it up. So it's not clear, not very often, the jurisprudence of CADE here has tackled issues of exploitation. This is clearly part of the antitrust toolkit in other jurisdictions. On paper, is also part of the Brazilian competition law, but it's not very much enforced. Now, when we have alternatives, it becomes easier to be assured about the lack of exploitation. And so here, traditionally, if we look at one ecosystem in isolation, of course, we want to favor interoperability so that other entrants can attach to the infrastructure. We want to favor switching to other services, but there will always be kind of advantage from the ecosystem orchestrator side, because they have better ability to cross-subsidize, navigate market complexity. They can shift the focal point that attracts all the other players, for example, from one platform to another. They have a lot of interdependence between their services and synergies that you cannot obtain simply by forcing interoperability. Interoperability only goes some way. You will not get the full package that the orchestrator has because of the control that it applies to the whole ecosystem. So again, interoperability is a partial measure. I think we need to think also about the creation of alternatives, maybe some industrial policy. And a final point that I cannot live without mentioning is that when you talk about ecosystem, there are several affected parties from the ecosystem. And so you should always take into account the possible harms, not just to the consumers, but the case, for example, of appification of services like the iFood, which is a very popular case in Brazil. What you have is lower prices, you have high volume of transactions. From the consumer side, it might be all brilliant, but on the other side, you have complaints of restaurants that are being excluded, but not only because of the exclusivity, but also because they are not fast enough. And this can deteriorate the quality of the service. It can deteriorate the safety of the whole society because people are driving very fast everywhere. So if you focus on a traditional concept of price and quality, price increase or quality reduction, you don't get the full picture of the stakeholders that are affected. So I think market and ecosystem failure should also take into account these other players that are often neglected, including workers that are part of the ecosystem. And so I think, to conclude, we need to give some leeway to the ecosystem orchestrator to adopt the best possible measure, but we need to also be vigilant, demand evidence, when contact or restrictions might seem pretextual or not strictly necessary to achieve a certain outcome. And we need to, in doing that, take into account also these other parties that are often neglected when doing traditional antitrust analysis. So I leave it to you and looking forward to the discussion if there's any time.
Thank you very much, Nicolo. As you're right, actually, if the ecosystem brings value, the main interest would be to keep and to promote the very ecosystem, but the orchestrator is not always aligned with this goal. And well, I'll open to questions by the audience. Just let me know if you have any question here within the public who is present. And Berardo, can you get from the online audience? Okay. Well, meanwhile, okay. Beatriz, you make the question here, the mic. Yeah, it's better to use the mic and introduce yourself.
So, hi everyone. I was moderating the previous panel, so maybe you know me. I'm Beatriz. I work at Maranhão. It's just a quick question because Monica mentioned the Data Act, and I think it's very interesting. I think it's something we should be discussing in Brazil. So, just... Sorry. Para ficar aqui? Ah, tá. So, I just wanted to hear your view about if you think the Data Act is an appropriate measure to deal with these market failures, specifically dealing with the access to data.
Thank you, Beatriz. Well, I don't think exactly the Data Act is the better way of dealing with these market failures, but I think that the concerns that arise and that they try to address are very important, especially when it comes to make conditions to interoperability. That is something that Nicola also said, I guess, and that's something that I think that the telecommunication sector has a lot of experience doing. For ensuring competition or for promoting competition, I think to make data flow is one important thing. Another thing that the Data Act may contribute to this discussion is the provisions that address some contract possibilities, the do's and don'ts of what can we do when sharing or trying to share data sets. So I think that the Data Act can contribute, but it's not the only model that we can follow or we can be inspired on. I think there is a lot of provisions that we can think on the Brazilian perspective how to do it. We can think about this on a self-regulation infrastructure as it is on the telecommunications side. So I think it's one part of the problem, but not the whole, because after this data is shared, we also need to ensure that more than one competitor has the ability to process this data. Because for me, it's a very important part of this market power that we are dealing with, and that we need to balance on the digital ecosystem.
Nicola, do you have any comment on the question?
Yes, I mean, we could talk for hours about it. Data sharing is a very complex remedy because it might also privacy concerns, right? So, but I think it's a fruitful way to show that you can at the same time, because of the non-rival nature of data, you can benefit third parties while maintaining value for the system orchestrator. So it's a good solution. The problem is how to find the parameters, the standards that prevent privacy violation. I think there are technologies nowadays that are making it more secure. But one point that I think we want to mention about the Data Act is that it has this restriction for gatekeepers, so big companies, that they cannot benefit from this data access that will be facilitated by the regulation. And this is a logic that, yeah, it's controversial because on the one hand, you could have these orchestrators, if they were regulated to operate fairly, we would trust that they would access this data and give more value to their own ecosystem thanks to these measures of the Data Act. But the legislator was very cautious. He said, no, I'm afraid that this legislation will end up being used mainly by the big gatekeepers, will create even more concentration of power. So it's a matter of what we believe, it's a priority. It seems that in the European Union, the priority for the moment was we need to tame big tech power, and therefore we need to prevent them from having access to this. But in a more idealistic world where we trust the orchestrator, maybe why not extending also this possibility to them?
Thank you. One last remark. I don't see the Data Act as a law ruling, a proposal, no? A regulation that is looking after correcting market failures. Actually, it has more the tone of an industrial policy. It's a way to foster the industry, the digital services which are based on data. So how can we foster the production and the sharing of data so that there is more services, more efficient service, and etc. It's not actually about regulating competition, but of course it has many implications to competition. And this aspect that Nicolo called attention to, the prohibition to share with gatekeepers, shows a very protective aspect or characteristic of the Data Act within an industrial policy in Europe. It's in that point, it's an industrial policy proposal, and that clause reveals a protectionist approach. Yeah. We have, when it's now 5:30, we have already another panel with closing remarks where we are going to talk about artificial intelligence. So I thank a lot the speakers of this panel. It was really a pleasure. I enjoyed a lot this discussion and all the contributions and insightful comments by all the panelists. Thank you very much.
Thank you.
Agora Bom, vamos então iniciar o nosso último painel, que vai tratar sobre inteligência artificial e os seus impactos em toda essa análise sobre concorrência nos mercados digitais, né? E acho que o que a inteligência artificial traz fundamentalmente em toda essa discussão é um grande question mark, né? Traz mais incerteza em relação a como lidar com essa dinâmica competitiva nos mercados digitais, né? Isso porque toda a análise e todo o debate trazido sobre regulação dos mercados digitais, ela é backward looking, né? Ela tem uma visão retrospectiva dos últimos 10, 20 anos de domínio das grandes plataformas digitais, e então busca medidas com base, principalmente no que vem da regulação europeia, com base em precedentes, para tentar criar contestabilidade a esse mercado e mais justiça na distribuição dentro dos ecossistemas, como nós falamos no painel passado, né? Mas a inteligência artificial traz uma provocação importante, que é: cadê o forward looking? Cadê a visão prospectiva nessa análise? Porque o que ela traz de evidência imediata é algo impensável há 5 anos, quando nós já debatíamos regulação de mercados digitais. Ninguém imaginava que ia surgir um player totalmente novo e adquirir uma posição tão importante como a OpenAI, um serviço novo de IA generativa, que então não só passa a ter um domínio num novo serviço, num mercado específico, uma posição de primazia nesse mercado, mas como provoca também uma corrida dentro dos mercados digitais por inovação e por investimento, e além disso, uma reconfiguração dos diferentes ecossistemas entre os orquestradores, num esforço de incorporar, dentre os diversos serviços que complementam, né, ali o ecossistema, também avanços em inteligência artificial. Então, isso provocou uma grande transformação, um chacoalhão, né, em toda a dinâmica de concorrência, que a visão retrospectiva assumia como estagnada. Daí a necessidade de criar ferramentas regulatórias para gerar contestabilidade, ao passo que o mercado, de novo, se antecipa o regulador e traz um movimento de contestação importante, que se não desestabilizou alguns mercados estabelecidos, o mercado de buscas, não foi ainda desestabilizado, mas extremamente ameaçado. Daí todos os investimentos em criar, por exemplo, da Google, criar um assistente pessoal, Gemini, que fosse incorporado à ferramenta de busca, porque surgiu aí uma possibilidade de transformação do mercado em que se consome informação digerida, já produzida pelo assistente, e não se faz uma busca propriamente, né? Então, em cima disso é que eu gostaria de colocar a temática para vocês debaterem, porque nós lidamos, até no painel passado, a Mônica mencionou que já existe a regulação per se em cartel, né? Mas quando a gente olha a experiência de cartel, em 2011 é que foi adotada a regra per se, né, de proibição de cartéis de conduta concertada. Se você pega os 12 anos anteriores, se não me engano, eu tenho um estudo que analisa esse histórico, foram 52 casos de cartel, todos condenados. E nenhum deles se viu qualquer perspectiva de eficiência que pudesse compensar os danos trazidos pelos cartéis que foram julgados e condenados pelo CADE. Quando a gente olha agora para as condutas que estão em jogo no DMA, no esforço de regulação do 2768, ou mesmo o estudo recente publicado pelo Ministério da Fazenda e outros esforços internacionais, as condutas são condutas verticais. E as condutas verticais, elas têm uma ambiguidade muito maior em termos de eficiência e até de histórico de condenação. Você tem um percentual pequeno de condenações. Vamos pegar a principal, self-preferencing, você tem um percentual de condenações muito inferior. E justamente você tem casos em que a empresa não é condenada em função do reconhecimento de eficiências ou de aspectos da dinâmica competitiva que descaracterizam a infração. Então, dentro de um ambiente já de incerteza, com práticas ou condutas em que há incerteza, não há um consenso no sentido de que é necessariamente anticompetitiva a conduta, você ainda tem esse ingrediente adicional da inteligência artificial que provoca uma dinâmica e uma pressão competitiva, uma disputa competitiva enorme entre os players na construção desses ecossistemas digitais que agora incluem. Né? Você fala também que em inteligência artificial você teria também efeitos de ecossistema com relação aos modelos fundacionais e outras aplicações em torno desses modelos fundacionais. Mas você também tem uma migração desse novo serviço digital, ou novos serviços digitais em inteligência artificial que se acoplam. Né? Por exemplo, o Copilot, que se integra ao pacote Office da Microsoft. Né? Também há um esforço, por exemplo, o Meta AI está colocado ali no serviço de mensageria privada. São mercados distintos. Né? Um é o assistente pessoal, o outro é mensageria privada, mas está na mesma interface. Em outros casos, não dá nem para dizer se é um mercado distinto. Né? Ferramentas de edição de texto, de escritório, em que eu integro IA, eu estou falando de um mercado de IA e depois de outro mercado, ou é um mercado já de edição de textos que incorpora IA. Né? Então, muitas dúvidas começam a aparecer que colocam mais incerteza num campo já de incerteza. Acho que é importante, nesse contexto, olhar para o impacto, tanto para o impacto econômico da intervenção do Estado, quanto para o impacto jurídico, em termos de segurança jurídica, dessas intervenções num ambiente de condutas verticais, que é pautado por incerteza e diante de um novo fator que chacoalha toda essa dinâmica que nos parecia estática, né, dos mercados digitais em termos de potencial de inovação e eficiência. Então, aqui só fiz essas considerações para abrir os temas de discussão e passo a palavra então para a Silvia. Mas o Berardo é que é o moderador.
Quer falar alguma coisa? Não, né?
Não, tá bom.
Bom, boa tarde a todos e a todas. Acho que ainda é boa tarde, sim. Quero começar agradecendo, no nome aqui do Juliano Maranhão, o convite para participar desse debate. Do que eu assisti até agora foi tudo muito interessante e muito importante a gente avançar nessas discussões e promovendo esse debate nesse ambiente acadêmico, especialmente, para a gente poder avançar um pouco mais nessas reflexões que estão sendo alimentadas diariamente com novas informações da vida real, né, do que está acontecendo no Congresso, está acontecendo nos ministérios, o que é política do governo, o que que são as preocupações dos nossos legisladores, e acho que ter a oportunidade de estar aqui conversando com vocês é realmente bastante único, e por isso eu agradeço, e parabenizo também pelo evento. Indo já, então, aceitando um pouco aqui das provocações que o Juliano trouxe, Eu acho que, realmente, como que a inteligência artificial tende a impactar os mercados digitais? Ela, obviamente, acelera esse processo de digitalização da economia que está acontecendo como um todo, né? Então, quando a gente discute mercados digitais, não são mercados digitais, a economia está se digitalizando. Tem mercados que começaram a nascer no ambiente digital, mas mesmo os mercados que já existiam antes, todos estão, em algum grau, virando digital e alguns vão virar no médio e longo prazo. E a inteligência artificial tem muito potencial de acentuar isso, de trazer ainda mais inovação. Então, nesse sentido, ser até promotora de inovação, de ganho de produtividade, que tem se mostrado como uma preocupação da política do governo quando você fala em regulamentar plataformas digitais. Produtividade é uma palavra que aparece com bastante frequência no relatório do Ministério da Fazenda. Então, nesse sentido, ela é um aspecto, ela obviamente tem um aspecto muito positivo. Ao mesmo tempo, o próprio CADE, na manifestação que ele fez, na contribuição que ele fez no debate do PL sobre inteligência artificial, foi também na direção de reconhecer essas eficiências, mas também reconhecendo que ela permite outras formas ou acentua a possibilidade de acontecerem práticas anticompetitivas, como discriminação de preço, conluio via algoritmos e outras diferentes formas. Pode ser que a inteligência artificial, ou pode ser não, ela vai também ajudar até a monitorar e talvez a investigar algumas condutas, mas por enquanto a preocupação é maior na linha de gerar dano do que de ajudar nas investigações. Então tem esses dois lados da balança e ao mesmo tempo as plataformas, a inteligência artificial deve favorecer para o bem e para o mal, nesse sentido, né, de uma forma pró-competitiva, de uma forma de favorecer preocupações concorrenciais, a formação desses ecossistemas, porque vai facilitar, vai favorecer que algumas plataformas passem a oferecer serviços que antes não ofereciam, ou complementem os seus serviços com atividades ou com produtos e serviços de inteligência artificial, e com isso aumentem o leque de produtos a serem ofertados para os consumidores, aumente a inovação, aumente a produtividade, mas também favoreça que grandes plataformas se fortaleçam com um número ainda maior de serviços, que se vale ainda mais de economias de escala, de escopo, de sinalidade de rede, ou seja, todos os elementos que tendem a favorecer uma concentração nesse mercado vão estar talvez ainda mais presentes de forma eficiente, mas também favorecendo essa concentração. Ou seja, acho que a gente vai colocar um peso grande nos dois lados da balança que geram esse efeito, né? O positivo e o que pode gerar as preocupações concorrenciais. E aí, nesse contexto, que eu acho que, diante do que a gente está vendo de debate aqui mais atual, que a gente tem, por um lado, o Ministério da Fazenda, de forma bastante apoiada pelos outros órgãos do governo que olham as plataformas digitais, levando adiante uma proposta que deve virar um projeto de lei sobre regulamentar, sob a ótica concorrencial, as plataformas digitais, e hoje, né, tem discutido, eu confesso que eu não sei a atualização das últimas horas, mas essa semana aí está na agenda a votação pelo Senado do projeto de lei sobre regulamentação de inteligência artificial. E o que eu acho que é bastante importante é que os desenhos regulatórios aí venham a conversar, venham a convergir, para a gente realmente poder ter políticas industriais realmente coerentes e que as coisas sejam implementadas de forma a não gerarem disputas judiciais. E acho que aqui eu começo já a criar provocações para a própria Josi trazer as inseguranças jurídicas da regulamentação das plataformas, né? Porque acho que esses desenhos regulatórios se mostram pertinentes em várias direções, alguns pontos, claro, podem ser melhorados, mas o debate em si é muito pertinente. Agora ele tem que andar junto, senão a gente vai ter grandes problemas de ter muito mais disputas judiciais do que implementação de uma regulamentação que possa ser pró-competitiva e pró-desenvolvimento. Acho que todos os países, inclusive o Brasil, estão agora diante de oportunidades muito ricas de saltos de produtividade, de saltos de inovação, e o desenho de como isso vai acontecer é muito importante. E, para isso, ter clareza nos objetivos também é muito importante. E aí é que eu faço referência, por exemplo, ao projeto de lei 2768, que também imagino que a Josi vai trazer alguns elementos para debater a esse respeito. Mas pegando como exemplo, é um projeto de lei que é super meritório no sentido de talvez ter sido o grande marco inicial da gente debater com mais concretude a regulamentação de plataformas do Brasil. Ao mesmo tempo, trouxe ali alguns, e acho que é reconhecido como ainda um primeiro esforço, ou poucas pessoas levaram muito adiante como realmente um projeto de lei que seria de fato implementado. De toda forma, Foi feito um esforço, até participei de um trabalho patrocinado pela LAI, sobre os impactos do projeto, os impactos econômicos desse projeto. Então, se a gente pegasse os critérios que estavam ali no PL 2768, o que a gente teria de plataformas sendo reguladas? E se a gente fosse pegar, primeiro que o critério de plataforma é difícil definir, sob a ótica econômica, jurídica, então é um desafio, né? Então, na hora que você tenta aplicar na prática o que seria realmente caracterizado como plataforma, é difícil. E o que a gente verifica é que, mesmo pegando cenários mais conservadores, ou seja, definições mais rigorosas do que poderia ser uma plataforma, a gente olha ali as empresas, e as empresas que faturariam mais do que 70 milhões de reais, tendo como referência 2021, acredito, 2022, 21, 22, a gente teria quase 300 plataformas sendo reguladas ou sendo designadas como alvo de uma regulamentação ex-ante. E aí, então, nisso eu coloco, será que esse é o objetivo de uma regulamentação ex-ante de plataformas digitais? Eu imagino que não, até porque do ponto de vista operacional seria bastante inviável, e você chegar a um número de 300 plataformas, você destoa até do conceito de gatekeeper ou de posição relevante sistemática, ou qualquer outro conceito que você possa usar para ali fazer uma seleção daqueles agentes que poderiam ser mais preocupantes. Então, aqui eu chamo a atenção para qual que é o objetivo e também para a importância e necessidade de se fazer a avaliação do impacto efetivo de que determinada regulação vai ter. Eu acho que o estudo do Ministério da Fazenda foi muito bem elaborado, muito bem feito, já trouxe várias evidências, e acho que é um convite, inclusive, a gente avançar a discutir eventuais implementações de regulamentação, sempre avaliando antes qual que vai ser o impacto regulatório disso. Quais vão ser, então, efetivamente, as plataformas que vão acabar virando alvo, que tipo de condutas, de fato, podem vir a ser reguladas. Então, a gente tem mecanismos para fazer esse tipo de avaliação. O Brasil já acumula alguma experiência fazendo isso para outros setores, digamos assim, regulados, e acho que a gente deveria se apropriar um pouco dessa experiência para avançar nessa direção. Mas olhando, então, de novo, esse exercício que foi feito de forma empírica para a LAI, a gente vê que, por exemplo, alguns segmentos, como no e-commerce ou no varejo, a gente teria 75 plataformas sendo reguladas. Não faria o menor sentido, né? Quando a gente fala em posição sistematicamente dominante ou de relevância sistemática, a gente espera encontrar 1, 2, 3 plataformas naqueles serviços, naqueles segmentos de mercado. Então, não é de se esperar que você tenha dezenas. Em outros, de delivery, a gente tem mais de 20 plataformas de deliveries. E o Brasil, nesse sentido, eu acho que a gente tem que chamar a atenção que o Brasil tem muitas especificidades. Que é isso, se eu tiver que perguntar aqui como moradora de São Paulo, que vai com alguma frequência para Brasília, se eu consigo nomear mais de 20 plataformas de delivery, eu não consigo. Por quê? Porque o Brasil é muito grande, então tem muita especificidade locacional, regional, de forma que a gente consegue gerar escala. As plataformas podem conseguir, a depender, claro, do modelo de negócio, depender da região, elas podem conseguir atingir escala mínima ou, nos termos digitaleses aqui, massa crítica para atuar de forma mais regional, não precisa ter uma atuação nacional. Então, isso, a depender, claro, sempre do mercado. Então, essa especificidade do modelo de negócio e de você olhar o Brasil, é olhar os vários Brasis que a gente tem, né? Olhar as várias questões locacionais que a gente tem. Então, de novo, avaliação empírica e qual que é o objetivo que a gente tem com determinada regulamentação vai ser muito importante, porque senão a gente pode estar gerando uma regulamentação que daí sim tem um efeito que é a preocupação de todos, né? De talvez barrando uma inovação para eventualmente permitir mais inovação. Então, tomar cuidado que é o que a gente estava conversando hoje mais cedo, né? Então, vamos barrar uma inovação para ver se assim sai mais inovação. Aí pode parecer um pouco incoerente, isso especialmente enquanto política pública, tá? Outros elementos que a gente traz com uma análise mais econômica é que toda intervenção na economia sempre traz alguma distorção. E, obviamente, isso não é motivo para você dizer que, então, não vamos fazer uma intervenção na economia, tá? Mas também não dá para desprezar que vai ter alguma distorção. Então, ter muita clareza de qual que é o objetivo a ser alcançado com aquela intervenção é bastante importante. Senão, também, você pode gerar uma distorção que nem vai ser na direção que você realmente gostaria. Então, esse é outro ponto importante aqui que eu gostaria de ressaltar. E aí, voltando, então, a importância de a gente ter a coordenação para que a gente tenha... Se todo mundo tiver com clareza, né? Então, qual que é o objetivo? Que o efeito vai alcançar esse objetivo, acredito que dessa forma a gente tem uma facilidade maior de chegar nessa coordenação que vai ser muito importante. que seja por projeto de lei de inteligência artificial, que busca ser assimétrico à medida em que ele confere intervenções diferentes para os diferentes níveis de risco que aquela inteligência artificial pode gerar. E a gente tenta comparar com a regulação assimétrica, que talvez foque em poucos agentes, né? Pelo menos o secretário Marcos Pinto tem sinalizado que imagina que dessa proposição que saiu do Ministério, as plataformas-alvo da regulação devem ficar ali em torno de 10, não deve passar muito disso. Tá? Talvez esses dois critérios não dialoguem e não precisem dialogar. Né? Não há uma necessidade que eles dialoguem, as plataformas vão ser reguladas com objetivos e metas diferentes, mas até para isso precisa ser claro que esses critérios não precisam dialogar, todo mundo que vai atuar nisso não precisa dialogar, o que não quer dizer que os órgãos que vão regular essas plataformas não precisem se comunicar, até porque os serviços que podem vir a ser regulados eventualmente pelo CADE, se avançar na direção que o Ministério coloca, esses serviços possivelmente vão se valer de inteligência artificial, se não de imediato, no futuro próximo. Então, esse diálogo vai ser muito importante. Então, o desenho institucional, o desenho de cooperação entre essas agências, um diálogo maior em como isso vai acontecer, precisa acontecer. E, pelo menos, eu não tenho a percepção que, a priori, isso já esteja acontecendo. Tá? Não que isso vá ser ignorado na hora da implementação, mas hoje isso ainda não está acontecendo. Tem ainda bastante tempo de debate, imagino eu, para que isso venha acontecer, mas queria chamar atenção para isso. E aí, nesse processo de diálogo, fazer essas análises, eu acredito que, eu quero acreditar, pelo menos, que o governo vai ter condições de fazer essa análise do impacto. Então, quem vai ser regulado, o que essa medida Ex-ante vai trazer de impacto, que limitação vou impor para os usuários profissionais, para os usuários finais, em decorrência de determinada limitação. Então, acho que são elementos que precisam ser mais bem explorados. Eu acredito que a gente tem experiência internacional em que essas medidas foram implementadas sem tanta avaliação do impacto ex-ante, e o impacto, pelo menos, está sendo feito ex-post, mas para a gente pode servir como uma referência ex-ante. Né? Então, toda a experiência europeia, do Reino Unido, da Alemanha, são experiências importantes para a gente ter como referência. A gente precisa usar o resultado que isso já tem gerado para a nossa experiência aqui. Claro que importar não é o ideal, mas pelo menos como uma referência mais empírica para isso. Então, eu queria aqui também passar, não dominar, não monopolizar todo o tempo aqui. Queria passar a palavra para a Josi, e eu acho que a gente, depois de passar a palavra para ela, ainda consegue fazer algum vai e vem aqui também, ouvindo um pouco a audiência e a plateia. Tá? Obrigada.
Muito obrigado, Silvia. Jo, se você achar ok, acho que a gente pode discutir primeiro a parte de IA e depois a gente faz as considerações sobre o report. A gente tinha combinado só para poder manter tudo dentro do mesmo... da mesma, vamos dizer assim, o tópico, né? Silvia, acho que uma coisa muito legal que você falou e que a gente, inclusive, estava conversando mais cedo... deixa eu até me mudar aqui de cadeira, que eu acho que fica um pouco melhor. Era a questão da gente realmente pensar para onde a gente quer regular as coisas, né? Claro que olhar para as experiências internacionais é importante, acho que é uma boa forma da gente ter as evidências, né, empírico, do que está acontecendo, mas aqui eu tenho duas questões principais. Uma, eu acho que a gente está começando a ter a massa crítica para os mercados digitais agora, né? Acho que a gente está chegando lá. Para a parte de inteligência artificial, me parece que a gente ainda tem muito para ver, para poder efetivamente fazer uma análise nesse sentido, né, olhando para resultados. A gente está ainda muito dentro desse processo. E outra questão, que acho que é uma pergunta até fundante de para que lado a gente está indo, é que não necessariamente a resposta que é dada por Estados Unidos, a resposta que é dada pela Europa, a resposta que é dada pelo Japão, pela Austrália, são as respostas que a gente quer. Né? Então, acho que é muito importante a gente não só pensar na experiência deles, qual é o que eles estão induzindo, mas também pensar de onde eles partem, né? Qual é a intenção daquela regulação e aonde ela quer chegar, né? E aí, se ela conseguiu chegar onde ela queria e quais foram os comportamentos induzidos. Então, se você puder trazer um pouco, acho que até da maturidade mesmo que a gente está nesse ponto de discussão, acho que seria bem legal.
Obrigada aqui pela pergunta. Eu acho que inclusive a gente parte de pontos diferentes em relação a essas jurisdições, né? Pega Estados Unidos e Europa, eles têm primeiro que a própria defesa da concorrência lá tem outro grau de maturidade, com outros objetivos, né? A gente vê, especialmente a Europa, por exemplo, trazendo, e é uma coisa mais enraizada na cultura deles, conceitos como fairness e contestability, né? Que faz parte já dentro da política antitruste dele, talvez de forma não tão explícita antes, mas que agora, aparentemente, pelo menos pelas oportunidades que eu tive de dialogar com alguns reguladores europeus, para eles esses conceitos são bastante intuitivos, né? Até para, como é que vocês fazem para avaliar fairness, especialmente? Acho que contestabilidade pode dialogar de forma mais direta com a nossa ideia de evitar a criação de barreiras à entrada, que sejam criadas pelas tecnologias, ou que as plataformas não criem elementos como dificultar a interoperabilidade, não fazer self-preference, seriam formas mais óbvias de você evitar, ou pelo menos garantir um pouco mais de contestabilidade. Mas fairness, né, o que seria de justiça, né, nem sei muito bem como é que a gente usaria isso, trazer isso para um enforcement concorrencial, né? O nosso enforcement concorrencial, inclusive, tende hoje ainda a entender que depois de uma fusão que reduz a sobreposição de vagas de trabalho, gerando reduzindo o número de pessoas empregadas na futura firma fusionada, isso é uma fonte de eficiência, pode ser entendido como uma fonte de eficiência. Então, talvez isso não seja exatamente o que esteja alinhado com o conceito de fairness que a Comissão Europeia adota. Então, acho que a gente não pode realmente importar esses conceitos, acho que a gente parte de uma maturidade diferente, de um desenho institucional diferente, dos Estados Unidos, né, o desenho institucional também é bastante distinto do que é o Brasil, mas eu acredito que até na semana passada, acho que tem um grupo de pessoas que eu até já encontrei aqui que estava também nos eventos ali do GDEC Cresce, discutindo aí as ondas de intervenção, e que talvez o Brasil e os países do sul global já foram mais, digamos, expostos e abertos a uma influência mais direta do norte global, mas que talvez hoje a nova onda mais recente é esse reconhecimento que a gente tem especificidades locais, a gente tem um ponto de partida diferente, e que talvez a gente olhar mais para dentro e mais para os nossos pares seja tão importante quanto olhar para as outras jurisdições, tá? E que talvez a experiência deles tragam mais exemplos mais práticos para a nossa tomada de decisão do que uma experiência europeia ou americana. O que não quer dizer que não devemos olhar para eles também, mas não apenas para eles. Acredito que o nosso início de antitruste aqui no Brasil se espelhou de uma forma muito mais direta, né? Pega nossos guias de análise de concentração horizontal, por exemplo, o entendimento que a gente tem sobre intervenção em casos de cartel. Para o bem ou para o mal, a gente importou muita coisa, mas talvez agora a gente já tenha também um pouco mais de maturidade, e agora talvez a especificidade locacional nossa, essas questões da gente ser um mercado consumidor muito grande, a gente tem uma base de usuários gigantesca, a gente consegue, digamos assim, ser bastante atrativo enquanto mercado para grandes plataformas, sejam estrangeiras, sejam locais. A gente consegue acomodar grandes plataformas locais com que elas atinjam escala de operação para serem eficientes. É uma realidade que não é tão comum em vários outros países, então isso precisa ser considerado. Tá? Espero ter endereçado pelo menos parte da sua pergunta, porque eu acho que ela é uma pergunta que vai ser viva durante muito tempo. Tá?
Não, com certeza, Silvio. Eu acho que o ponto é justamente esse, né? Que a gente está ainda num processo realmente de discussão dessas questões. E aí uma questão que você trouxe da interoperabilidade é um ponto até que me lembra que a gente não tem que olhar só para todas as questões de direito que estão envolvidas e de política, mas também para a parte técnica, né? Quando a gente fala de plataformas interoperáveis, quando a gente fala de serviços que eu possa levar meus dados de um lugar para o outro, isso não necessariamente é tão tecnicamente simples quanto juristas e economistas querem crer. Tem toda uma arquitetura por trás que normalmente, inclusive, é proprietária, né? Então eu tenho problemas ali de gerar uma interoperabilidade do que exatamente, de quanto, por exemplo, das minhas informações pessoais que estão numa plataforma revelam também o modelo de negócio dessa plataforma por trás, né? Então acho que tem uma questão aqui nesse ponto. Tem questões que foram levantadas sobre segurança, quando eu falo em interoperabilidade também, porque muitas vezes eu tenho menos controle do meu ambiente, e aí isso pode me gerar um trade-off de segurança. E não é dizer que eu precise optar por segurança, ou que eu precise optar por não revelar certas informações, mas eu preciso estar ciente de que eu estou fazendo essas opções. Né? Eu acho que isso é uma questão super importante, e aí daí eu acho que é tão relevante a gente olhar para as experiências dos outros países, né? Uma vez que eles tomaram essas opções, quais foram os trade-offs e quais foram esses impactos, né, que foram gerados. E numa perspectiva até da parte de tecnologia, a gente também importa e importou, e acho que ainda continua, talvez, importando ainda com uma certa relevância, os estándares europeus, né? É só olhar toda a discussão do que foi a LGPD, de como são os guias que a gente tem na parte de proteção de dados, apesar de já existir críticas, por exemplo, como inclusive a gente conversou mais cedo, sobre uma perspectiva individualista de proteção de dados, quando na verdade deveria estar olhando para uma proteção mais coletiva, né? E como eu posso fazer esse shift dentro do que eu tenho hoje de normas e como isso pode ou não, por exemplo, inclusive beneficiar o desenvolvimento de inteligência artificial, né? Se eu for levar a ferro e fogo exatamente o que está determinado dentro das leis de proteção de dados, talvez eu não consiga gerar treinamento de modelos. Mesma questão para a parte de propriedade intelectual. Se eu não levar em consideração o desenvolvimento tecnológico na hora de ler todas essas coisas, talvez isso seja uma questão. E aí o ponto que eu queria levantar é que, claro, né, a gente está enfrentando a inteligência artificial nesse momento, e eu acho que isso é um ponto sempre de questão, mas não é como se fosse a primeira tecnologia disruptiva que a gente viu. Né? Então, acho que se você puder trazer um pouquinho também de paralelos com outros momentos, né, que a gente possa ter olhado para tecnologias disruptivas e falado, tá, a gente precisa dar um passo para trás, vamos repensar como a gente pode fazer isso de maneira diferente. É preciso fazer isso de maneira diferente, se sim, como. Né? Então, acho que tem muito também da gente tentar olhar para as experiências anteriores e pensar que essa não é a primeira disrupção que a gente está vivendo. Né? Então, talvez existam experiências aí para trás que façam sentido da gente olhar e aprender com como fazer essas conexões.
Não, assim, muito bom ponto. Mais uma pergunta viva que a gente ainda vai ter que continuar debatendo. Mas, assim, de fato, essa é uma discussão muito multidisciplinar, e até por isso que faz todo sentido que você tenha diferentes órgãos do governo debatendo e que, eventualmente, os órgãos reguladores não vão ser um único órgão, mas vão ter essa interação, como propôs o relatório do Ministério da Fazenda, uma interação com outros órgãos. Então, é um tema muito multidisciplinar. Eu acho que cada vez mais a gente vai estar aqui na Faculdade de Direito ou de Economia ou de Engenharia ou de Sociologia e outras várias faculdades discutindo, até porque quando se discute inteligência artificial é inevitável que se venha à tona, então, quase o outro extremo, né? Por um lado, você tem toda a questão da ciência de dados, a importância dos dados, como processar os dados, o algoritmo, toda a parte mais da engenharia do negócio, mas também o que sobra da inteligência artificial que não vai ser, ou se vai ou não vai ser incorporado para a inteligência artificial, que é todo o lado humano. Então, o que nos diferencia de máquina? Então, tem toda uma discussão, e acho que tem aí a pergunta de $1 milhão é o quanto que a inteligência artificial vai realmente superar o homem ou não, né? Você pega discussões mais filosóficas sobre isso e que poderia estar motivando uma intervenção maior, porque talvez essa seja uma tecnologia disruptiva muito mais séria, digamos assim, do que todas as outras, porque finalmente estamos perto de alguma coisa que pode chegar perto de superar o homem. Então, agora tem uma inteligência ou tem uma tecnologia que joga xadrez melhor do que o homem, que faz algumas coisas melhor que o homem, mas tem várias discussão filosófica, social, de coisas que a máquina ainda não vai saber fazer, né? Então, quer dizer, existe uma discussão se vai ou não vai conseguir fazer, né? Até que ponto a tecnologia vai permitir fazer isso ou não. Então, nesse sentido, eu me considero otimista por achar que essa tecnologia disruptiva ainda não vai ser capaz de superar alguns atributos que a gente tem, seja do ponto de vista de ter de sentimentos, a uma questão de olhar para problemas e ter uma questão de resolver algumas coisas ao mesmo tempo agora que aparentemente a máquina ainda não faz, por mais ágil que ela seja. Então, tem alguma expectativa de que a máquina ainda não vai superar o homem. Então, nesse sentido, ela é disruptiva, mas não um disruptivo que precisa de um freio mais importante do que outras inovações que aconteceram no passado. Acho que talvez uma grande inovação mais recente é a própria internet. Né? Eu vi esse processo acontecendo, eu tenho dados suficientes para ter visto isso acontecer, para ter usado o telefone que gira uma bolinha no meio. E a internet eu demorei para entender o que poderia ser a internet, e eu não vejo ela ter tido tantos freios assim, e talvez tivesse tido, a gente talvez tivesse passos atrás ainda. Claro que teve, do ponto de vista mais tecnológico, várias questões, tem ali o Marco Civil da internet também, que são são marcos importantes, mas eu acho que na época da internet não teve tanta discussão sobre regulamentar como está tendo hoje. Mas talvez a gente esteja só vivendo mais um movimento associado aí da internet, que então, no fundo, a grande evolução foi a própria internet. No fundo, a inteligência artificial pode ser entendido como mais um elemento disso. Acho que sobre isso só a história vai dizer. Mas sobre a inteligência artificial, até isso se coloca, né? Tem uma frase que eu não vou conseguir citar precisamente, mas alguma coisa assim... o futuro no passado já não se faz o futuro como se fazia antigamente, né? No passado, a gente olhava para o futuro com um pouco mais de certeza do que a gente olha hoje, né? Então, isso traz muita certeza. Mas olhando para a inovação disruptiva que foi a internet, a ver se a inteligência artificial vai ser um pedaço disso, ou se ela vai ser maior do que isso, eu sou otimista. Eu enxergo que a internet foi menos regulamentada do que está se discutindo hoje regulamentar inteligência artificial no contexto de plataformas digitais. Mas eu também acho que, pelo menos, as discussões são legítimas. Ainda está difícil dizer se os desenhos que vão prosperar no Brasil são os mais apropriados. Mas a discussão me parece bastante legítima. Então, não consigo comparar se no passado deveríamos ter feito diferente. Bom, se a gente olha a Revolução Industrial e todo o êxodo rural que gerou e todos os problemas sociais que foram gerados por toda uma Revolução Industrial, talvez a gente olhasse para o passado e fale, talvez fosse meritório da gente ter feito alguma coisa um pouco mais organizada, porque isso também gerou diversas desigualdades, diversos problemas. Então, nesse sentido, acho que a gente também tem que olhar com um pouco mais de cuidado dos efeitos sociais que isso pode gerar. Isso certamente, mas não vejo a priori a necessidade de uma regulamentação também muito mais agressiva do que já está sendo discutida, ou que a internet em si a gente deveria ter feito diferente. Tá?
Obrigado, Silvia. E são realmente perguntas bastante vivas, né? Acho que se a gente tiver essa conversa de novo daqui a alguns meses, talvez daqui a pouco, depois, semana que vem, depois que eventualmente aprove, a gente já tenha outras conclusões para traçar. Mas acho que o ponto, na verdade, também é muito esse, né? A gente está dentro dessa discussão. E aí eu gostaria de passar a palavra agora um pouco para a Josi, para ela apresentar um pouco das conclusões do estudo do Legal Grounds, que inclusive está sendo lançado. A gente tem alguns exemplares físicos aqui para distribuir para o pessoal que está presencial. Mas acho que para trazer também um pouquinho de como que está a maturidade disso, quais são eventuais conflitos, né, do que a gente tem como prática no CADE, quais são, né, as conclusões do estudo. Josi, por favor.
Berardo, obrigada. Queria agradecer também a Silvia, que trouxe de uma forma brilhante a efervescência toda que a gente está vivendo hoje, globalmente, com a questão de mercados digitais e IA. O objetivo do report que a gente está lançando hoje é justamente ter uma lupa específica para uma iniciativa que está em trâmite no Congresso Nacional, que é anterior ao estudo do Ministério da Fazenda e que traz uma sofisticação e preocupações que são muito importantes e que a Silvia já trouxe bem sobre o Ministério da Fazenda observando e trazendo critérios para você delimitar melhor quem vão ser os regulados, né? Então, a gente faz no report uma avaliação sobre esse projeto de lei que traz como critério para definição de quais seriam os regulados um faturamento que traria essa enormidade de regulados, cerca de 300 empresas, então, que poderiam ser objeto de obrigações ex-ante. Então, para além desse problema que a gente identifica também no report sobre o tamanho, quem regular, né, que é um debate que é muito relevante, a gente tem uma investigação mais precisa sobre a própria metodologia que o 2768 trouxe para definir quais são as obrigações ex-ante e quais são, eventualmente, as sutilezas do comportamento dos players que podem ser avaliados ou não. Então, assim, o nosso exercício foi tentar fazer uma análise de impacto que não foi feita antes da elaboração do projeto, fazendo um paralelo, um confronto entre qual seria a possível metodologia a ser aplicada com o cenário de aprovação, né, desse projeto de lei, versus a metodologia que é aplicada pelo CADE há décadas para avaliação de condutas anticompetitivas. No capítulo que a gente já publicou e que vai ser distribuído aos colegas que estão aí presencialmente no evento, a gente faz um recorte e faz uma avaliação específica de condutas discriminatórias. Então, a gente faz uma avaliação do que seriam, então, condutas entendidas, né, o que poderiam ser objeto de regulação do projeto de lei sobre uma perspectiva de discriminação. O artigo 10 do PL 2768, ele traz uma série de obrigações aos detentores de poder de controle de acesso essencial. E aí, no inciso 2, ele traz o dever de tratamento isonômico e não discriminatório na oferta de serviços a usuários profissionais e finais. Essa é uma disposição que é bem ampla, ela é mais ampla do que é previsto, por exemplo, no DMA, quando vai tratar especificamente de condutas de self-preference. O que a gente fez para fazer uma avaliação de quais seriam essas obrigações ex-ante, né? Então, a gente confrontou as disposições do artigo 10 com a metodologia aplicada pelo CADE nos últimos 10 anos, em precedentes que sejam sobre discriminação em mercados físicos e digitais. Isso foi necessário até porque a gente não tem, até como o Juliano colocou, uma jurisprudência do CADE já madura e ampla, que faça uma avaliação de mercados ditos digitais, né, que tenha as plataformas como foco específico. E aí a gente faz uma pergunta, né, será que a aplicação dessa regulação ex-ante traria um índice maior de proibição de condutas? Então, poderia trazer uma quantidade maior de falsos positivos e negativos, se confrontada com a metodologia que é aplicada pelo CADE. E aí a gente ensaiou cenários a partir do que dispõe o artigo 11 do PL, porque no artigo 10 a gente tem as obrigações que seriam avaliadas ex-ante, e tem o artigo 11 que traz alguns critérios a serem avaliados no momento da aplicação das obrigações. Então, traz, por exemplo, o inciso 1 fala sobre a adoção de critérios técnicos, isonômicos e não discriminatórios, fala sobre uma avaliação de imposições específicas a depender da modalidade da plataforma, fala sobre uma intervenção proporcional ao risco existente e outras disposições nesse sentido. Mas qual que é a dúvida, né, que a redação do projeto de lei traz? Esse artigo 11, ele é uma avaliação que vai ser feita pela autoridade regulatora, né, antes de definir a obrigação para o regulado, ou essas seriam meras análises para avaliar atenuantes ao comportamento que já é pré-definido e já é exposto como proibido ex-ante, né? Então, a gente faz, como a redação não é clara do dispositivo, a gente não sabe bem qual é o papel, então se é um rol de justificativas legítimas a serem avaliadas antes da tipificação, ou se, na verdade, seriam atenuantes, a gente fez, então, a elaboração de 3 cenários, e a partir deles foi fazendo uma avaliação de como seria uma análise com base no projeto de lei versus o que a gente teve como resultado de uma análise do CADE nos precedentes que foram levantados, né? Então, dentre esses cenários, o primeiro é o artigo 11 como mera atenuante, ou seja, o artigo 10 teria obrigações a priorísticas, já tipificaria proibições que seriam per se, e o artigo 11 traria apenas avaliações de moderação para uma eventual sanção, por exemplo. Num segundo cenário, a gente faz uma consideração que, na verdade, o artigo 11, ele é como se fosse um guia para você definir a tipificação do artigo 10. Então, e aí, dividindo esse cenário em 2 subcenários, um cenário em que a observância a um dos pressupostos que está no artigo 11 já seria suficiente para você entender que a conduta é permitida, versus um segundo subcenário em que você teria que fazer uma ponderação considerando todos os fatores e entre prós e contras, entre condicionais contributivos, você iria definir um placar, né? E a partir disso você conseguiria definir se a conduta é permitida ou proibida. E, finalmente, um terceiro cenário, que seria uma coincidência entre a avaliação que o regulador faria do artigo 11 como critérios para uma avaliação tal qual o CADE faz a metodologia. Então, aí a gente não teria obrigações per se, mas aí a gente teria uma coincidência, né, entre as disposições do projeto de lei versus a metodologia consolidada do CADE para análise de condutas a posteriori. Esse terceiro cenário, ele não é tão relevante aqui para o debate, porque a gente teria uma coincidência, né, entre o que o CADE decidiu e o que o regulador provavelmente decidiria. Então, os problemas, eles se concentram, sobretudo, quando a gente faz uma avaliação do artigo 10, no primeiro cenário, como uma proibição ex-ante, e aí a gente teria um cenário de forte divergência com a jurisprudência que foi estudada do CADE, e também no cenário em que você teria uma ponderação de critérios para definir se seria ou não uma obrigação ex-ante, considerando se o player observou ou não todos os pressupostos que estão lá no artigo 11. Então, a partir da avaliação de uma série de casos, a gente trouxe tanto casos de mercados físicos, então tem mercados de tags para automóveis, estacionamento, tem questões relativas ao mercado de gás, tem questões precedentes que tratam sobre taxas e no mercado portuário e entre operador versus o detentor da infraestrutura, tem casos também de ferrovia, aviação, e também os casos que são mais próximos e que são, de fato, análises em mercados digitais, que são principalmente o Google Shopping e outras avaliações que houve também, análises do CADE sobre mercados digitais e tendo o Google como investigado. A partir da análise que a gente fez, quais foram os resultados, né? Para além de um problema com o próprio conceito do poder de controle essencial, que a gente foge do que o CADE traz como um critério ou uma avaliação do que é de poder de mercado, quando você coloca faturamento sem considerar possíveis impactos no mercado, o efeito que você tem é uma regulação que traz uma avaliação de uma enormidade, né, de players, inclusive aqueles que não seriam de fato relevantes, pensando, por exemplo, sobre um aspecto nacional, né. Outra avaliação preocupante é que a gente avaliou que existe um nível de divergência muito relevante entre as decisões do CADE e quais seriam as potenciais decisões partindo dos critérios do 2768, especialmente no cenário 1, em que a gente teria um 100% de divergência, considerando que, nesse caso, você teria na verdade, não é 100%, porque o CADE tem condenações em alguns casos, mas seria muito próximo disso, um nível de divergência, considerando que, nesses casos, não seria feita nenhuma avaliação de poder de mercado, eventuais eficiências ou justificativas legítimas de negócio. E no cenário também em que você faz ponderações sobre se existe legitimidade ou não na conduta a partir da avaliação de todos os critérios que estão no artigo 11, a gente teria aí um índice de divergência de 44%. Então, qual foi, né, a conclusão que se trouxe? Que existe uma presença grande de e sobre-inclusões, que são que é uma característica de regulação com base em regras, que é o caso do 2768, quando traz, no artigo 10, uma hipótese de regulação ex-ante. E isso se torna mais problemático, considerando que há um histórico baixo de condenações do CADE em casos de discriminação, e a gente, então, não tem uma massa crítica, né, para chegar a conclusões sobre qual seria uma possível postura do regulador já pré-definindo, diferentemente, por exemplo, do que o Juliano trouxe, que quando você definiu cartéis como condutas a priori, per se, anticompetitivas, você já tinha um histórico em que o CADE condenava 100% dos casos de práticas colusivas. Então, o que não é verdade, o que a gente não tem no cenário de mercados digitais. E aí, se de fato, né, a regulação ela tem uma preocupação com segurança jurídica e com o objetivo de ampliar bem-estar social, melhorar o ambiente de negócios e incentivar investimentos, que a gente pode ter numa aplicação de uma regulação ex-ante nos moldes, né, do 2768 seria, na verdade, o inverso. A gente poderia ter uma intensificação das preocupações com segurança jurídica e um risco grande de sobre- e subinclusões, então, condenar condutas que seriam eficientes sob um ponto de vista concorrencial. Então, é isso, basicamente, em breve síntese o que a gente investigou e trouxe como conclusões no report que vai ser entregue a vocês.
E por apresentar tão claramente os pontos do report, né? Ele é um report bastante denso, inclusive, então obrigado por trazer esse overview, né? Acho que é super importante até para quem for ler eventualmente dar uma olhadinha para realmente dar uma guiada, que é um report bastante profundo, né? Então acho que é interessante de pegar essa explicação. Obrigado, Josi. Silvia, para alguns comentários finais, antes da gente encerrar o painel, por favor.
Aqui, eu só pedi a palavra para comentar um pouco o estudo que eu achei, e parabenizar também a Josi e o Juliano pelo estudo, que eu acho que é uma abordagem muito interessante. Acho que é esse o tipo de exercício que eu comentei, que sob a ótica econômica via lá e a gente fez nos impactos. Acredito que foi feito sob a ótica jurídica e acho que eles são bem complementares e chegam à mesma conclusão. Só achei interessante amarrar dessa forma, porque, de fato, a gente identifica também bastante incerteza na hora de identificar ou tentar traduzir os critérios para o que seria, na prática, então, essas plataformas que mereceriam ser reguladas. A gente também percebe que os critérios parecem ser não só pouco precisos, mas insuficientes. Então, você também tem um critério que é objetivo por um lado, mas que no fundo é único, acaba sendo insuficiente para você realmente conseguir caracterizar aquela plataforma como algo realmente meritório de uma regulamentação ex-ante, e que tem um conjunto de incertezas ali na hora que você vai lendo um projeto de lei que dificulta muito, do ponto de vista econômico também, você ter clareza de qual que vai ser o efeito final daquilo. Então, acho que todos esses elementos que, acho que de uma forma, com óticas diferentes, a gente buscou entender, a gente chegou em conclusões muito parecidas. Aqui eu não detalhei muito o estudo, justamente para também não dominar com a metodologia, com um monte de critérios, mas aqui a gente claramente percebe que tem muita plataforma que jamais deveria ter sido alvo de uma regulação ex-ante, que na verdade talvez tivesse até a função de justamente ser quem alimentava ali a concorrência naquele segmento de mercado, tá? Então eu só queria fazer essa consideração, que eu acho que os estudos convergem e acredito que esse é o tipo de exercício que deveria acontecer antes de implementar qualquer nova regulamentação. E acredito que até tem esforços nessa direção, mas espero que tenha tempo e que o debate vá nessa direção, seja da ótica jurídica, econômica, social e todas as outras disciplinas aí que podem ser afetas por uma possível regulamentação. Tá?
Silvia, muito obrigado pelas suas considerações. Obrigado, Josi, pela participação e pela apresentação do relatório. Vou agradecer ao professor Juliano, que infelizmente teve que se ausentar por conta de um compromisso posterior, mas agradeço a ele também. Aos presentes aqui fisicamente, aos online também, muito obrigado por participarem do primeiro dia do segundo simpósio de mercados digitais. E amanhã nós teremos as apresentações de trabalhos que foram selecionados. Essa não será transmitida online, mas estão todos convidados a comparecer e assistir as apresentações amanhã, também de 10 às 5h30 da tarde. Muito obrigado.